Wow, good afternoon and welcome to the Appellate Division First Department. I want to say that we have a lot of observers today. We have interns from the DA's office and legal aid. Don't talk to each other. We have observers from the AGC. We have our own interns here and a couple of other different groups. So I want to say to everyone who is arguing today and for us on the bench, get out your A game because we've got company, and like the Knicks in the fourth quarter last night, let's get
Yes.
right? Show them what you got. So we have almost 6.5 hours of argument time requested. Obviously, we're not going to be able to accommodate all that argument time. Be assured, we've read your briefs. We've thought about your arguments, and we are here. And so when you ask for argument time, please only ask for the time that you absolutely need to get across your most salient points. And if we have additional questions, we will ask them, okay? So I'm going to call the first case, People versus Samuel Ocampos. For the people? I'm sorry, for the defendant? Okay. Yeah, I'm going to give you 5, 2, and 5. Okay? Kozovsky versus Kozovsky. Okay, I'm going to give you 5, 2, and 5. P Children is submitted. Jin versus Delta Realty Group. Okay, Ms. Jin, I understand that English is not your first language. Do you want to argue, or you can submit your briefs and we will issue a decision based on the papers in the case? Or if you want to argue, I'm sorry, we don't have an interpreter here, so it's up to you. Are you sure? Okay, I'll tell you what. There's no one here to argue against you, I don't think, so I'm going to give you 2 minutes, okay? And or you can submit, whichever you like. But I'll give you 2 minutes if you want them. I know. In the trial courts, they have interpreters on staff. We don't have interpreters on staff in the appeals court. I'm sorry. If we did, I would absolutely have one here for you. So but I mean, you've put in your brief, and we can do a decision based on your brief. We don't have that here, no. I know, it's not the most ideal situation, but I can either you can try and argue in English if you like, or we're perfectly good with taking your papers on submission. There are other parties who don't orally argue, they just do their arguments on the written documents, and we can take the written documents and make a decision on that if you like. It's entirely up to you. But let me know what you want to do, because I've got lots of other stuff going on. I'll give you 2 minutes. There's no one here to argue against you. It's only you. You want 2 minutes? Okay, good. 2 minutes. Aponte versus 298 East Village. Okay. Respondent? Oh, wait, we have 1, 2, 3 respondents, right? Okay, so. Okay. Okay. So, okay, I'm going to give you 5 and 2, 6, 2, and 2. Okay? All right. People versus Javier Pantojas. 4, 1, and 4. Tobin versus Turner Construction. I'm going to say 6, 1, and 5. Miller versus 22 Erickson owner. 5, 2, and 5. Almer Summit Glory Property, and there's a cross appeal on this, right? Okay. Okay, let me just, 5 and 2. And then who's here for Summit, Fosun, and Benchmark? 5 and 2. And who's here for Tri-Ram? Okay, and who's here for Almer? Yeah, I'll probably give you, I'm going to give you, because I've given everyone else 5, 2, and 5, I'll give you 7, but you have to respond to everybody in your 7, okay? All right. Okay, thanks. Judson versus Elliott Management Corporation. Okay. All right, 5, 2, and 5. People versus Campbell. I'm not going to try and pronounce that first name. Who's got, are you for the defendant? How do you pronounce that name, please? All right, we'll just, Mr. Campbell, we'll call him Mr. Campbell. All right. 5 and 1, and people? 4, okay. DeKalb County versus Gallon. All right, I'm going to give you 6, 2, and 6. Rubino versus HSBC Bank. Okay, and for PHH? Okay, so you're not going to separately order? Okay, and, yes. All right, I'm going to give you 5, 2, and 5. 5th and 106th Street versus Hunt. Okay, we don't have a respondent here. Do you still want to argue? You can submit if you like, but I'll give you 2 minutes if you want. Okay. No one ever says no to 2 minutes, huh? People versus Unique Woodfin.
I would request 6 and 2, Your Honor.
All right, I'm going to give you 5, 2, and 5. And Singh versus Singh is submitted. Okay, so our first case for argument is People versus Samuel Ocampos. Counsel, you may begin.
Good afternoon. May it please the court. I am Danielle Godwin with the Office of the Appellate Defender for Mr. Samuel Ocampos. The officer who stopped Mr. Ocampos in this case exceeded his authority at every stage of the encounter. What started as an unjustified stop escalated to...
Why is it unjustified? Didn't he have reason to stop him based on the window tint and the, what was it? The license plate that was not illuminated?
That is what the officer testified to during the suppression hearing. It's unjustified in our opinion, just given the circumstances of the stop in the first place. Seeing window tints late in midnight from the expressway from a perpendicular position, and also there's no, his
Counsel,
testimony.
wasn't that specifically credited by the trial court? Why should we not give deference to the credibility determination of the trial court?
That is, I guess, up to your honors, but it just based on the officer's testimony alone in the video, which doesn't start until after the stop, we believe there's some incredibility there. But the most problematic issue with the stop here is the search that occurred, specifically the invasive nature of the search.
There was consent to that search, correct?
Mr. Ocampos did consent to the search, but the officer, when he asked Mr. Ocampos for his consent, didn't actually have any founded suspicion of criminal activity.
Well, he had the smell of marijuana in the car, which at the time was unlawful, correct?
Correct. We also question the credibility of that testimony, considering Mr. Ocampos did admit to having a small sealed metal container of marijuana in the car, unburnt marijuana. The officer never testified to whether he smelled burnt or unburnt marijuana, and he admitted that he never saw smoke.
At the time, they had run his license and he was on a suspended license, correct?
Yes, that's
At
correct.
the time he did the first search, the officer already knew that your client was on a suspended license.
Correct.
And he had stopped him for what the trial court credited as a legal stop for excessively tinted windows and the plate. And he's wearing body camera, right? He's not trying to hide anything. The body camera video went into the trial court, the hearing court, right?
That's correct. But again, the issue here is the extensive nature of the search. If you watched, as I'm sure your honors have the video, you'll see it at the 11-minute mark, you see the officer prying a window control panel open. At the 13-minute mark, while we can't see what's happening in the video because the officer's body-worn camera is presumably facing the seat, we can hear a very extensive search occurring. You hear snapping, prying.
At the time that he pries open that panel, he did that, he testified based on his experience and training in identifying traps in cars, correct?
That's correct, but he didn't have any evidence that Mr. Ocampos in this case was doing anything drug-related other than the small container of marijuana that he admitted to, which he found 30 minutes into the search, yet the search continued for over 7 more minutes after that.
I suspect your friend is going to raise the issue of the validity of the waiver. So do you want to get out in front of that? Because I think that if there was a valid appeal waiver, that would preclude the suppression issue before us, right?
Well, Mr. Ocampos didn't make a valid appeal waiver in this case, primarily because the court conflated the rights that were given up when pleading guilty and the rights that are given up when waiving the right to appeal, which respondent acknowledges.
I think respondent acknowledges that it was a misstatement that in the same sentence was corrected, right?
It was not corrected in the same
In
sentence.
the same sentence, he talks about the appeal waiver, I think it's she.
She,
talks
yes.
About the appeal waiver that you just executed, right?
That's correct, but even if she made that statement, the specific rights were never clarified. It wasn't clarified that these were rights given up when pleading guilty.
Have we ever said anything about that there has to be an exhausted list?
No, not necessarily, but
So if we look at the totality of this waiver, it complies almost exactly to the model colloquy, right?
with the exception of the error made by the court, which again was never clarified.
Okay, but assuming that the error is a misstatement that was corrected in the statement, there's nothing else. It's exactly what the model colloquy requires, right?
Almost. I think there's some variation, but it's close.
And
I think
there's no doubt that he discussed the waiver with his lawyer,
he did discuss it.
and he signed it in open court.
He did sign it, but there's also no evidence, or the court did not ask Mr. Ocampos specifically if he had read the written waiver, or if he understood it to his own ability. He only asked if he understood it the way that his attorney described it to him. But again, even just given the conflation, again, may I briefly conclude?
Yes.
Just given the conflation that the court made, I don't think that it restricts the court from reaching the merits of this case, and I can finish on rebuttal.
Thank you. Counsel?
Good afternoon. Emily Aldridge for the People. As Your Honor indicated, absolutely the suppression claim is precluded by the valid waiver. But even if this court were to reach the merits of the search, the record demonstrates there was probable cause for the search.
Can you address the panel, the removal of the panel? Why was that justified to the extent that there was a moderate or faint smell of marijuana, and there was a pat down that had no results?
Well,
Why was removing the panel justified?
it all goes into the step-by-step process. So once he goes into the car, and again, there's the smell of marijuana, there's the admission to marijuana, which was valid to conduct the search under the law at the time. He then also requests permission, which defendant grants, and then he...
But I mean, the defendant said, sure, search the car, but he didn't say take the car apart, right?
Yes, but this is similar to Gomez, in which there as well, there was again, a step by step. So he goes in and he's in the Honda Pilot, which he recognizes from his training experience is one that has a natural void under the console and frequently houses what he refers to as a trap. He then sees that there is this loose part, and then he looks, he sees the pistons, he sees the wire. In this court address.
Does he see the wire? Does he see the wires before he starts digging around?
My recollection is that, of the records, that when he sees the loose panel, so he looks under the loose panel, and then he sees.
What's the justification for moving that panel at all?
Well, he knows that he's allowed to do the search, and that this court has addressed the propriety of looking at
When
these.
you say he's allowed to do the search, I assume that you mean for search for marijuana, because at the time, that's what he suspected was in the car. So are you saying that an officer under ordinary circumstances is allowed to remove panels on the interior of a car in the search for marijuana?
Well, I would point, Your Honor, to this court's decision in Rivera, where it said that looking under the center console, once the center console has been modified, that such a search is proper scope where.
So what you're saying is because he saw the modification, he saw the wires coming out and the looseness, that gave him the ability to look further.
To at least take the next step.
Sorry, which rubric are we talking about? Are we talking about de Boer? Are we talking about automobile exception? Are we talking about consent?
Combination thereof. So he certainly could look into, here as the court found two alternative grounds, both given the smell and admitted possession of the marijuana, that allowed the search. Also, there was the consent, which then that goes to the de Boer level. But here, given the totality of the circumstances, including the driving a car with a felony suspended license, he admitted that he owed the DMV $25,000.
I'm just questioning the relevance of I'm questioning the extent of the search. In other words, it's one thing to look under and around, but this was actually dismantling a portion of the car, and what was the nexus between that and the stop?
Well, there was
no gun.
There was no dismantling until he actually gets to the precinct and takes the photo and sees the gun inside. Before, it's just a removal of a loose panel, similar to.
No, that's what we're talking about, just the removal of a loose panel.
But that's what this court allowed in Hurtado. And here,
Clarify, did he see the wires and the piston before he moved the panel? He had to remove the panel first, correct?
I believe he removed the panel first.
By the time that he removed the panel, he had no awareness of pistons or wires underneath.
Well, he was aware that
He's aware that this type of vehicle is used often if you want to put a trap in a car, this is one of the cars you get.
Absolutely. And as this court found in Rivera, that looking at the trap under there, it was particularly reasonable in light of observation the console area appealed to be altered to create a hiding place for drugs. And that's what that certainly is what he suspected upon finding this. This may be a hiding place for drugs. It's worth looking. And then he looks, he sees the wiring, he sees the piston, and then later on he takes the photo, he sees the gun, he sees this. It's only upon seeing this, without doing any
Without taking apart the panel, which then led to all these other findings.
Precisely.
Would he have had the right to bring the car to the precinct?
Well, he certainly had the right to bring the car to the precinct.
For a stop for marijuana?
I'm sorry, maybe I might
For a
have
stop for marijuana where you have a smell and nothing?
Well, here it was more than just the smell. It was also the driving on suspended license, car not registered to him. This wasn't even something where he could have issued a summons. He didn't have an ID.
Thank you, counsel.
Thank you.
Thank you. Just addressing a few quick points on rebuttal. First, as Your Honor referred to, Mr. Ocampos gave general consent to a search in this matter, even if his consent was valid. He did not consent to a search.
Is there such a thing as a specific consent?
Not specifically, but
I mean, using the
to-
term general consent, do we have an understanding as to what that means?
Just, I think The scope of the search should be what a reasonable person would understand a search to a car to mean. It wouldn't mean prying open a window panel with a tool. It wouldn't mean slamming, as we hear in the video, the center console open, prying it, snapping it apart, metal popping off, as the search that occurred here. And the officer never asked Mr. Ocampos for additional consent to do
The
that.
defendant object and say, please don't remove the panels?
He did not, but he was also occupied by an officer with other questions at the time, and he didn't have to object when the officer had no authority to do this. The officer had no probable cause to conduct the search that was occurred here. As this court found in Ponder, even the strong odor of marijuana, in addition to the de minimis amount of marijuana consistent with personal use, does not allow an officer to
It wasn't
conduct.
just that, then they ran his license. He's driving a car on a suspended license. He couldn't get back in that car himself. The only thing they could have done is brought the car down to the precinct. So the police officer certainly is not going to get into the car without searching it to make sure that there isn't something going on, like a gun that could go off, right?
Sure, but a search of just the areas that Mr. Ocampos had access to does not include the interior of the center control panel, which again, there was no indication that was altered. A loose panel doesn't indicate an altered center console panel. So in addition to that, with respect to the odor of marijuana, MARTA is a new statute, which is in People v. Martin, a case that is pending before the Court of Appeals, and there's a decision pending before it. May I briefly conclude? But before this court, again, the officer did
Although
not,
we've held that it's not retroactive, right?
not necessarily,
the-
there, I meant there is a pending case in Riviera that this court hasn't decided yet.
Oh, okay, okay.
Yes, just with respect to that, that is an issue that would be dispositive, and if it found in Mr. Ocampos's favor, would require dismissal. But again,
The
the
second
officer,
department rule on this, aren't they saying it's not retroactive? It's
yes, but the third department has found that retroactivity does not apply, and that in this specific circumstance, that the court should not have considered the odor of marijuana, which in this case, the officer never testified to having experience in the detection of, or experience or training in the detection of marijuana specifically.
Thank you.
Thank
Thank you both. Kozovsky versus Kozovsky. Go ahead, counsel, yes.
Good afternoon, Your Honors.
Good afternoon.
Stephen Kirkpatrick for Appellant Gertrude Kozovsky, may it please the Court. The core issue on this appeal is that the Supreme Court essentially applied two different evidentiary standards, one for the appellant, one for the respondent. The appellant had submitted proof on a number of the claims in the accounting, and yet the Supreme Court rejected those claims. However, the respondent, for a number of the claims, did not submit proof, and the lower court affirmed and granted those amounts. The most clear example of this is there was a construction award amount.
Right, there was nothing put in, no documents, no, just that here's the construction, it wasn't substantiated, right?
But
Those
that's not
numbers.
correct, Your Honor. There actually was proof in the record for that amount. And in fact, the respondent, in its brief at page 12, acknowledged that the appellant paid $5,087. So that was conceded. There was proof in the record, yet the court held that there was, did not grant that amount. Similarly,
counsel, the 5,000 was for moving costs,
Moving costs.
not construction costs.
I'm sorry for moving costs. My apologies, Your Honor.
It wasn't, though, you didn't put in any documents for the construction costs, right? Only, you did put in documents for the moving costs.
We did put in for the moving costs.
Okay.
The construction cost was the $37,000 amount, and for that, the referee expressly ruled that it was subject to proof by Karen. However, Karen never submitted proof.
Right.
It was something that had been asked for during the referee hearing, but yet there was no proof that was ever submitted by Karen, and once again, the lower court, granted that amount notwithstanding any proof.
So can we talk about the property that's allegedly in storage for a moment? Because it's a little concerning. On the one hand, you have a claim on behalf of your client who says, during the course of construction, my property was removed by my daughter from the apartment and was placed into storage. And she has a whole itemized list, and she has photographs, but there's no valuation as to that. On the other hand, you have the daughter who says, yes, I have a storage place unit in Connecticut, but I don't know where it is, and that's that. So what are we to make of that?
Well, the
Or is
story.
that no longer an issue?
Oh, it is an issue, Your Honor. So there actually are a couple of different issues. There is documentation in the record regarding the value. There was a painting. There were some furniture items. I think there may have been a couple of paintings.
Paintings and the furniture supposed to be in the son's apartment or home, right?
Right, but there were things that disappeared, and there was a claim for that was asserted by Gertrude. So that's one item.
Was there information as to the value submitted below?
There was, Your Honor, yes. Let me just see if I have that quickly, or otherwise I can provide it during rebuttal, but I can find that. I don't have it. It's a long record, but yes, there was, I believe it was an appraisal report that was submitted in the record, and for rebuttal, I can look that page number up and provide it. But the other issue is that Gertrude paid, various costs for storage, even though there was an offer of free storage space, and it turned out that there was this mysterious storage unit that the location was never identified, someplace in Connecticut that neither Karen nor her daughter Alexa, when they testified during the referee hearing, could recall the location of. And that was paid by Gertrude, and we don't believe that Gertrude should have had to have paid for that, Your Honor.
Okay.
Thank you.
Counsel?
Good afternoon. I'm Mark Caruso from the law firm of Abrams Fensterman. Your Honor, the referees was tasked to hear and report. That gives the judge full latitude to either accept, confirm, or reject her findings. The judge examined the record and was very clear that we asked, we're the only person that moved to either reject or confirm the report. The appellant never moved. But we asked to have the court reject 5 of the findings, and all 5 were rejected. So, with respect to the one that my adversary didn't talk about, the relocation costs, which is the biggest ticket item on this list, there's no doubt that the appellant received 100% reimbursement for everything she
Right.
paid.
You mean the insurance payment?
Absolutely.
Yeah. Okay.
Okay?
Yes.
So
She was, yes, except she should have been paid for the cost of insurance because she was insuring somebody else's stuff. So that is, but yes, absolutely, the collateral source rule,
Okay.
okay?
So I won't belabor the point, but just remember that the insurance covered the entire apartment, and when there was a loss, the insurance company paid.
Your client
loss.
was the one who got the benefit of that insurance without
Absolutely,
paying
but-
any money for
But
it.
we're speaking here about reimbursement to the appellant for out-of-pocket, and there's no out-of-pocket, so
Right.
therefore no reimbursement from the respondent.
Okay.
With respect to the award of the reduction of maintenance to the respondent,
Where did that number come from?
so number one, we have no idea. Number two, there was no showing.
34,000, is it have any relation to monthly costs?
Monthly cost was $6,700. The per diem cost was $233. It bears no relationship.
nothing in the
Nor does the
record that
referee try
says
to
it.
explain where that number came from or why. And there
No,
was
I know.
no attempt to show damages. There was There was no denial of access. There was no intentional denial here. What happened was she had the mother had difficulty accessing the apartment, allegedly on 2 occasions. Yet at her deposition, she was very clear that she was never without access. We asked her at the deposition to point that out, and she said she can't. She always had access.
Okay, but the plaintiff seeking the $5,000 for the moving costs and put in documents.
And the referee was not clear as to why she didn't give that.
Exactly.
And the court was not clear as to why it didn't give it. But the appellant testified repeatedly that the insurance paid for everything. The insurance paid for the hotel, the insurance paid for storage, the insurance paid for moving. So I think
Let's say
that's
we
the
agree
reason.
with you as far as not having a windfall. Let's just talk about the stuff, the property in the storage facility.
Okay.
Because it's very concerning that the daughter made an admission against interest and said, yes, I have a storage facility in Connecticut, but I don't know where it is, and I don't know what's there. I don't know what I put there. What are we supposed to do with that?
So let's look at the claim that there was personal property. Number one, the personal property, remember, the mother never lived in this apartment. The daughter was the only person from day one, 2001, who lived
That's
there.
not the issue,
No, but
counsel.
let me get there.
No, that's not the issue. What are we supposed to do with an admission against interest such as this?
So the only list in evidence is the 2001 inventory of the personal property that was left behind by the seller. There is nothing in the record to establish a value for any of the personal property. And if you look at that list from 2001,
There's photographs, right? But other than
from
the photographs,
2014,
right, from
but we don't, remember there were 2
Counsel,
casualties
it's really
here. There were
helpful if you
leaks
don't,
constantly.
counsel,
The plaintiff
it's really
testified.
helpful if you don't interrupt when people are talking.
I'm sorry, you want to bet my lights on?
No, I don't, so?
So the bottom line here is there's nothing in the record to establish, one, that my client did dispose of anything. There was nothing to establish what was there when at the end of the 20, she was in the apartment for 20 years. There's nothing to show what was there, what was disposed of in the normal course of things, what the mother may have authorized. It's just the record is silent as to that. And there's just no support for a finding that there was a picture worth $8,000, so the mother should get $4,000, and there was furniture and other rugs and whatever. There's just nothing in the record to support that finding. Any questions, Your
Friend
Honor?
said there was an appraisal. Is that true?
I don't believe there's an appraisal in there, Your Honor. And if he can show it, I'd be surprised. Thank you.
So regarding the appraisal, it is in the record, Your Honors, at page, beginning at page 1216.
Can you say that again? I can't hear you.
The appraisal is in the record at pages
The
1216.
appraisal of what?
The appraisal of artwork and property. It was
As of what date?
as of, it was for a gift tax return, and I don't see a date on that.
What did it appraise?
So there were, the first item was an artwork called the Stella, which the appraised value was $50,000, and a quarter of it was $12,500, presumably. That was a gift tax issue. Then the next, so we have the Stella artwork, and then
And it
we.
was your client's testimony that that was in the storage facility?
No.
Well,
It's
what basis is it to award her any on that?
because it disappeared, Your Honor. We don't know where it
Well,
went.
why is that on the respondent?
Because that was my client's property. My client had an
Yeah,
interest.
but it's so, but why are we blaming the respondent for it disappearing?
Because she was in possession. It was in the apartment that she occupied. She put it somewhere and never explained where she put it. It was, she had custody of it, Your Honor, these items, and they disappeared. So that is the reason for responsibility. Regarding the,
Where does the $34,000 number come?
I want to address that. So that is an allocation of a portion of the maintenance payments for a period that my client was excluded from the
Doesn't say,
apartment.
that's not what, it says nothing about it, just 34,000, and
But
no
that-
explanation for it.
But there is, the record is clear.
I don't, I mean, I read the record, and
No, no, no.
the reason why I'm asking you is because I don't think the record's clear at all
Well,
where
the-
that number comes from.
I believe the record is clear, number one, Your Honor, that my client was excluded from the apartment. We had to file an order to show cause to get an order for access. That was opposed. When you are not denying access, why would you oppose an order to show cause to compel access?
I think because you said you had access all along, but
But-
okay,
but-
thank
but-
you, yes. I appreciate it.
Thank you, Your Honor.
Thank you both. Ponte versus 298 East Village.
Jen,
Did I miss, I'm sorry, no, I'm sorry, forgot. Ms. Jin?
Good afternoon.
Good afternoon.
Yeah, so I have, first, I have one case number 26007 in appeal team. I won. Say Bronze Court business.
Yes, I saw. The appellate term reversed that trial court decision, yes.
So I have 5 people. Everybody have.
We saw them, yes. We've all looked at them. We got it. We understand that the order was reversed.
Thank you. Second, I have one case number 100224. Before judge gave me the dismissed. So I want the court give me come back, not dismiss, come back, go to the Supreme Court.
We understand your argument. We got it.
Thank you.
Okay? Thank you. All right.
I go home now.
Yes. Have a good day. Now, Aponte versus 298 East Village. Yeah, right. I mean, normally we have, oh, yeah, oh, I see, we don't have enough chairs.
I don't mind if she sits with me, that's all good.
Good. I'm sure you see each other in a lot of cases.
We're friends.
No bad blood.
We
Okay.
are friends, we are friends.
Okay.
All advocates here, right?
Yes.
Okay. Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant.
Okay.
The trial court in this case, you know the facts, the trial court in this case denied summary judgment to the plaintiff on 2 grounds. First was whether the 1-foot elevation of the A-frame dolly platform was an elevated related risk. The second one was whether plaintiff's act of moving the dolly was a sole proximate cause. I'd like to start in reverse. Let me start with the sole proximate cause issue. First of all, we know under Blake and its progeny, the plaintiff can't be a sole proximate cause when there's a statutory violation. Here, our position is there's a statutory violation. But more importantly, there are several cases, we cited 5 in our reply brief, 2 I want to focus on, that specifically from this court has held that a plaintiff moving a material on an A-frame dolly cart at most is comparatively negligent, which is not a defense to 240. If you look at Nayante, which is 238 AD3D 643, the plaintiff is moving the cart loaded with several metal sheets. The cart tips over, and here's what this court says. This is at 643. That plaintiff may have moved the cart by himself when he was not supposed to amounts at most to comparative or contributory negligence, which is not a viable defense. Moreover, plaintiff could not have been the sole proximate cause of his accident since defendant's labor law 240 violation was at least a proximate cause thereof, see Blake. The next one, which is significant, is Hernandez against Port Authority. 238 AD3D 408, it's in my brief. Plaintiff encounters a dolly, this is particularly on point. Plaintiff encounters a dolly loaded with sheets of masonite, attempts to move it out of the way where he needs to work.
So,
Dolly-
counsel, let me ask
Sure.
you a question. Your client says somebody, some unnamed site guy, told me to move the dollies. And defendants all deny that. So why doesn't that create an issue of fact as to whether or not 240 liability, with respect to 240 liability? If he was supposed to leave it, if he's supposed to just leave it alone, I mean, it wasn't his job, right? So he's not supposed to touch it. They say, we told him not to touch it, and nobody told him to move it. He said, I was told to move it by, he doesn't remember who, and he doesn't know who that person is. Why doesn't that create an issue of fact?
Because, for two reasons. The first is plaintiff testified that when he first got to the site, he met the GC and a safety person. By name, he doesn't know. He's not tasked with knowing that. He came to the site, was given instructions, worked on the first, second, and third floor, leveling the floor. So he speaks to them, finds out his orders. Then, when he goes to the first floor and finds there's a dolly, he testified, right, that he went and he asked someone, the same person.
There's a dispute.
So what? No, but the reason why, respectfully, Your Honor, is not a dispute, because if you look at the affidavit of Nick and Farmer and Hershkovitz, here's what they don't do. The most important thing is, at best, paragraph 6 is a standing order. They never say, I told him, do not move the dolly. What they say, I'm sorry, paragraph 4 is, paragraph 6, I was right. Workers for subcontractors, including employees of Liquid Gold, were told by myself and Mr. Farmer to speak directly with us if they needed materials or object to move to carry out their work. At best, that's a standing order, which doesn't support a recalcitrant worker defense under the legions of cases in this court. There's no evidence. They said, do not move this dolly. They claim they didn't say anything to him. That also doesn't mean that there wasn't someone else from OTL at the site that actually said what they said. All they're claiming is that I didn't say that to them. But if you look at the safety plan and you look at the contract, OTL most certainly had safety members there, safety managers or coordinators. So these affidavits do not dispute that there was a 10 to 15 metal sheets on a dolly, 200 pounds with the A-frame, unsecured, no ropes, no anything, what the defendant admits, actually concedes that they didn't provide that, fell over and pushed him to the ground. So that's undisputed. It's also undisputed that he was never told not to use the dolly. All these affidavits show and say it actually establishes the propriety of summary judgment to the plaintiff, in my opinion, in our opinion, plaintiff's opinion, because it shows that this dolly was overloaded, unsecured, and unsafe, and nobody said, do not do this. That's what you have to do. Under this case law, to be a recalcitrant worker, you have to be given an instruction not to do, you can't not to do something, or to be given another safety device which you for no reason choose not to accept.
Counsel, if there's, as you say, a violation of 241.6 with regard to being unsecured, would that be at most comparative negligence on the part of your client?
If he moved it, you're saying?
Yeah.
Well, 246, 14, you can have fault. I mean, it is.
I'm talking about under 240.
Oh, no.
Let me you mind?
I'm so sorry.
Maybe it was a little awkward.
Sure.
How can you, I may have said it correctly, I apologize.
I'm sorry for
No,
that.
it's on me.
Okay.
Let me rephrase it.
Sure.
Under 240,
Sure.
if there is a statutory violation, is it possible that there should be sole proximate cause? I say it's simpler.
It can't be under Blake and its progeny if there's a statutory violation that's a proximate cause, which of here there is. He can't be the sole proximate cause. And here, there is clearly a statutory violation, and under.
But he could be a recalcitrant worker, and you're saying he's not because there's no evidence that anyone told him not to move it. Got it.
Should I answer and reply?
No, I think you're good. Thank you.
And I would say yes to you. Thank you.
All right, so 298 East Village, you have 6 minutes, right? Oh, okay. So you have 2 minutes. You're doing your 2 minutes
No,
first?
I'm the one with 6 minutes, Your Honor.
Oh, you're 6 minutes.
Yes,
I'm sorry.
Steve Tapley
Okay,
for
right,
Premier, and I've
okay.
got the 6.
Okay, got it. Yes.
May it please the court, I'd like to first address the issue that counsel spent her argument time on, and the defense that I briefed in the court below, which we believe to be a valid defense is that this plaintiff is not protected by labor law sections 240 or 241-6 because he did not have
I mean,
the
we have a
authority.
lot of law. Yeah, oh, I thought you were going to say because there's not a sufficient height differential.
I believe that to be the case.
I mean, we
but
have a
wasn't
lot of
going to-
law authority on that, right?
The height, yes, Your Honor, but if the plaintiff did not have the authority to move the equipment of another trade, then we don't even have to address the question of whether the combination of height and weight and distance would be sufficient to render this a 240 case. And what we
Well,
know.
I think, but that's not right, because if there is, counsel was correct. If there's a 240 violation, then there can't be, most there is comparative, and that wouldn't work. It would have to be recalcitrant worker, right?
No, Your Honor, and the reason I say that is I recognize what Blake said,
Yeah.
that where there is a statutory violation, there is no room for sole comparative, proximate cause. But what the Court of Appeals has also held in its cases, and what this court has held, is that when an employee is acting outside of the scope of his authority, he is not supposed to be working on another trade's equipment. And I could point to this court's case in Nelson, where an employee of a roofing contractor volunteered to help move a refrigerator, and this court said he was volunteering to do the work
But
of
in
another
this
trade.
case,
It's
the
not a
guy
240.
clearly has to clear this floor, right? And that's on the floor. So he's doing exactly what his foreman told him to do. But in order to do it, he's got to get rid of those sheets, right? So this is not a case where he said, gee, I'll be nice to my friend and move the refrigerator. He had to clear the floor, and part of that was clearing the floor,
Well,
right?
He didn't have to clear the floor because he could have.
Wasn't that his job? Wasn't he
his
doing
job
that?
was to put pins on the floor.
Right, so he had to clear the floor to do that,
And
didn't he?
if there had been a forklift there or a scissor lift, and he jumped into the forklift and tried
That
to
wouldn't
drive
be a
it away.
240 violation because it wouldn't matter, right?
So you're-
There's no height differential, right?
Well,
That's a different
you-
case.
well, addressing the cases that plaintiff cited, Nianta, plaintiff's job was to move the cart. He just wasn't supposed to do it alone. In the Hernandez case that plaintiff cited, the foreman said, I would have done the same thing. So clearly that was within the scope of authority.
So here we have the plaintiff saying he asked trade workers to move the dolly, and they said it wasn't theirs. He asked the site safety worker to have the materials moved, and he was told, move it yourself. And what you're saying here is what? That it's a credibility question that raises a question of fact?
Exactly, Your Honor. And in addition to that, Mr. Karopas, in his affidavit, stated that after the accident was reported to him, he saw that there was one A-frame dolly in the room, and it was standing there flush against the wall, whereas plaintiff said that the A-frame dolly had fallen down, it was on the floor.
You're saying there was no accident?
Well, according to the Karopas accident reports, which plaintiff affirmatively relied on and introduced into evidence, the accident occurred when plaintiff attempted to move one metal sheet off of the A-frame dolly, and it slipped and cut his leg. So these are credibility questions that would prevent the grant of summary judgment to
I looked at the
plaintiff.
medical report, and I thought there were injuries that way exceeded a laceration on a leg. He got the,
He has a laceration on the leg, which
you
resulted in
say
a
when the
degloving
skin goes off
injury.
your top.
He has a
Degloved.
degloving injury on the leg, which is what the laceration was apparently referring to in the accident report, and he claims that when he fell down, he injured his back. But what he told Karobas after the accident is that he was trying to move a metal sheet, one metal sheet, and it slipped and cut him. And that is a completely different version of events which does not present.
Where is that version?
That version is in the incident reports that were cited by counsel for Liquid Gold in her brief, and they appear at pages 812 and 817 of the record.
What do you make of Mr. Cosentini's testimony that unsecured materials on a dolly were unsafe because they could fall out? And Mr. Cosentini being OTL's principal.
He said that, yes. According to plaintiff's version of the facts, however, what happened was that as he held the handles with his elbows bent, like I'm holding them, it flipped backwards. He didn't have time to take any evasive action, but it was the top of the dolly itself, not the panels, that initially struck his knee as the first part of his body that was hit, and then went down towards his foot. I don't know how that could possibly happen where something is yay high and he's this close to it, and it doesn't hit his chest, it doesn't hit his pelvis, it strikes him on the knee, and it was the dolly that struck him, not the loose panels. So I think that the loose panel issue is kind of a red herring, other than if, as his accident report indicates, he was trying to simply take one panel off of the dolly and it slipped and it cut his leg. Thank you, Your Honor.
Who's up next? Who's going to argue next?
Good afternoon, Your Honors. Anthony Lohman, I have OTL Enterprises and 298 East Village owner. I want to echo everything Mr. Kaplan said. In addition, I should point out that in the underlying case, we had the affidavits of the two supervisors, Nick Karopis and Jewel Farmer, who were the only supervisors on site. They said that the testimony—
Counsel, did they testify that there was no site supervisor on site safety supervisor employed by OTL because the building had had 8 stories?
Yes, it had, I believe it was a 6 or 7 story walk up in the East Village.
8 or less, I'm sorry.
Yes.
And therefore, they weren't required to have site safety supervisors?
Correct. It's our position that there was no site safety supervisor.
Did you just say that there was a site safety
There was not.
supervisor?
There was not.
There was
It
not.
was a small building in the East Village. There's not tall buildings in that part of the city. Well, there wasn't until recently. Our position is that this site safety supervisor is a fabrication. There was no site safety supervisor. Both men signed affidavits that they never told plaintiff to move the dolly himself. Also, plaintiff's employer, Mandy Herskovitz, also submitted an affidavit that said if there was any problems, he was supposed to call.
But I mean, is that enough for a recalcitrant worker? Assuming that there was a statutory violation, is it enough for your people to say, we never told them to do that? Is that, does that?
Well, first of all, he had no foreman on site. He was the only Liquid Gold
Okay,
employee.
assuming that he thought somebody else was the site supervisor, is it enough for you to get out of your 240 liability by simply saying, we never told him to do that?
Yes, because his
What case says that?
his boss, Mandy Herskovitz,
No, what case says that?
I don't have a case ready on that point,
Okay.
but this his boss, Mandy Herskovitz, submitted an affidavit in support in Liquid Gold's opposition papers, which said he was supposed to call Mandy Herskovitz if there was a problem with the dollies in the way.
Okay.
Thank you.
Thank you.
Good afternoon. May it please the court. My name is Magdalene Skunzos from Brody Law Group for Liquid Gold.
I want to, because I guess in your brief, are you saying that the plaintiff gave 2 different versions of the accident?
I'm saying different versions of the accident absolutely exist. The plaintiff is claiming that a dolly tipped. He doesn't say why the dolly tipped. And if I may, Your Honors, there's testimony I want to cite that's in my brief from page 189 of the record. It's plaintiff's deposition testimony. As you sit here today, do you have an understanding of why the A-frame with the metal sheets tipped over? Answer, yes. Question, please tell me what that is. No response. Question, why did it tip over to the best of your knowledge? Answer, I don't know why it tipped over, to be honest. I don't have an answer to that.
Okay,
So
that
I-
doesn't, but it tipped, but that is a different thing than saying that it wasn't that the dolly tipped over, it was something else.
So that's plaintiff's version, that the dolly tipped over. He doesn't know why. He doesn't say there's anything wrong with it, which is why I want to distinguish Nienta and Hernandez. Both of those cases cited by the plaintiff do prove violations because there's something wrong with the dolly. One had a crack wheel.
I want you to focus on what you think the other version of events is.
Okay, that was what counsel started to say. There's an incident report that was prepared by Nick Karupas, which said,
Was he there? Was he there? Did he see the accident?
actually, Judge, nobody saw the accident. There's
Right,
only
so
one.
what is the basis of the accident report?
He's the competent person for the site. He's the,
Oh, absolutely, he can write the report, but I'm saying, what does he base his statement about the accident on?
if you give me a minute, I'll look for that. The other incident we're relying upon is the C3 incident report, which was submitted to the Workers' Compensation Board, which also said he was going for a piece of metal as opposed to a
He
dolly.
says it?
Or the accident is attributed to a piece
Counsel,
tripping over.
the question is, what is the source of the information?
Let me get that 1 second, Judge. I'm
Yeah.
sorry, I'm working on it.
Yeah.
And the other thing I just want to point out, this was a motion that was
I
made.
don't see you looking.
Sorry, I'll look and talk. This was a motion that was made before everybody testified. Not everybody got a chance to testify. So this isn't even a complete discovery, completed action. And let me look to answer your questions because I'm not trying to be recalcitrant.
No,
so to speak.
we have some documents, it's good.
Okay, and then that brings me to my next point. Our argument isn't that plaintiff was a recalcitrant worker. We're saying that there's a question of fact as to whether he was the sole proximate cause of the accident. The lower court was correct in denying summary judgment based on the record. Tribal issues of fact exist, discovery's not complete, different versions of events, and the court got it right, and we ask that you affirm it. If you'd like, can I take a minute to look?
Sure, but let me let.
And thank you.
People arguing. too,
Thank you.
Right, okay, go ahead.
There's a lot to say. I'm not going to be able to do it all in 2 minutes, but here's the most important part. First of all, there's no two different versions of the event. The defendant didn't produce any version. This is an unwitnessed accident, and there's nothing produced by the defendant to challenge
What about the
plaintiff's
workers'
credibility.
comp statement?
Well, I'm looking at the workers' comp board report of first injury, and here's the accident injury description. 15 to 20 panels of metal that were on an A-frame dolly fell on me, and he lists the additional body parts that were hurt, including his back that he had surgery for. So I mean, to the extent of the injuries, that's not subject to a plaintiff's motion for summary judgment on liability. I'm not quite sure why we're discussing the extent of the damages. To suggest that they have no evidence that this accident didn't occur the way it did, there's
Is there
no
an
evidence
incident
to
report
refute.
that we're talking about that has a different variation of the accident?
There is no different version of the accident. At 8:12, I'm looking at, are you talking about 8:12?
Yeah, 8:12 to 8:17, I wrote.
Yeah, 8:12 to 8:17. He was trying to move a piece on a rack, and it slipped out and hit his leg. Okay, how is that different than moving
Well, I
the
think-
cart and the metal falls on him?
Who's the source of that information?
Well, it looks here like it's hearsay.
Okay.
I understand that.
Okay.
It's hearsay, but the workers' comp, okay. But the plaintiff's testimony stands, nobody's refuted plaintiff's testimony. They didn't produce any witness. Let's assume we don't have that. We don't have the workers' compensation form because it's inadmissible. And this workers' compensation board form as well doesn't look like it's signed. Let's say we just disregard that. What do we have? We have plaintiff's testimony. That's not been refuted, that the material and the dolly fell on him. And there's no, in response, in order to defeat summary judgment, they have to show adequate safety devices were provided. He was recalcitrant. That's the standard. They didn't meet their
Is
burden.
there a tribal issue of fact as to whether the plaintiff was acting outside of the scope of his
No.
duties?
No, Your Honor. I mean, I know my light's off, you've asked me. To that extent, this has nothing to do with Nelson. Nelson is just a helper. Here, the plaintiff was a worker, and of course, under Pratt's, you don't isolate the moment of the injury. This is preparatory work, and even Constantino testified that he could never have done this work unless the first floor was cleared. So he had to move everything. So this was work that he had to do.
Someone had to move.
He was a suffered worker. He wasn't just a volunteer that decided to come and help move a
He
refrigerator.
was called a volunteer, wasn't he, in one of the briefs I think, premier. He was a volunteer who chose to act outside the scope of the work by moving another trade's materials.
He was called a volunteer, but this record actually belies that because he was hired to perform leveling work and he had to move the cart. So it's nothing like this Nelson case. This was a suffered worker who's supposed to be there, who was following the instructions and had to have had a clear floor, but there wasn't. And because nobody else moved it, or he was told to move it, he had to move a cart that was unsecured.
Thank you.
Thank you
all.
very much. Thank you.
I'll look at it. We'll all look at it. We've written down. Okay, thank you. People versus Javier Pantojas.
May it please the court, Amy Donner for Javier Pantojas. Since my reply and opening briefs fully addressed point 1 of my brief, the prosecutor's summation issue, I'd like to focus my oral argument on point 2, which is the sentence issue. In sentencing analysis, the most significant factor is the personal status of the defendant before the court. Mr. Pantojas has an IQ of 68, the bottom 2% of intellectual functioning, and severe cognitive processing difficulties of information. And for second-degree murder, the legislature has set a range, in addition to the life sentence, they've set a minimum range of 15 to 25, and all your honors have to decide is the earliest time that the parole would really give my client, if there's any
Counsel,
relief.
did defendant express any remorse for an alleged cold-blooded murder of a person on Christmas Day?
He didn't make a statement, Your Honor, at all, and he didn't make any statement, and he can't.
Isn't that part of the framework or guidelines that the courts look at, whether or not there should be a reduction of the sentence as being excessive? Isn't that one of the main requirements?
The court has to look at the person before the court, and he has trouble, they said, expressing himself in English or in Spanish, in anything with his IQ, and processing information and verbal, he's bottom 2%.
He was able to get a gun, right?
That is true, Your Honor.
And he admitted that he was a member of the Latin Kings.
That's not clear either, Your Honor, because no, there's nothing in the record, there's nothing in the pre-sentence report saying it. So even if it's, so I'm not sure about that, but even
I didn't make that up.
I didn't say definitely not, that I know, but
He had enough wherewithal to find a gun and buy a gun.
That part is
So
definitely
he's
true,
not,
definitely.
he's not someone who can't function.
He definitely did have that, but
What's the relationship between a defendant's educational or intellectual deficits on the one hand and the severity of the sentence that's imposed on that defendant on the other?
I'm sorry, what was the first part of your question? What's the relationship?
What's the relationship? So you're citing that as a prominent factor as to why we should exercise our power to reduce the sentence. How should we factor those deficits, those intellectual and educational deficits, into whether the sentence was excessive?
It's mainly the cognitive, the IQ and the cognitive, because you have to look at the individual, and if somebody has a lot of trouble, severe cognitive processing in the 2% of the population, processing information and an intellectual functioning, and in the heat of especially in the heat of the moment, as that report from Dr.
What heat of the moment, counsel? What heat of the moment? He was told during the course of the incident, he was told by Aguayo, the person who allegedly began this whole chain of events, that the person that the defendant was targeting was not the person who was involved in the argument. So I don't understand you.
I'm sorry, what is the question about? I'm sorry, what is the relationship?
I think the import of the question was it wasn't heat of the moment. He was given an opportunity to step back and move on and do and to to not shoot him point blank on Christmas Day, and he didn't do that. That's not a heat of the moment. The guy isn't punching him.
The whole incident happened in a very quick time, and he's somebody who has difficulty processing. Now he's already served also 16 years. But and also going back to Your Honor's question about the Latin King allegation, I mean, this wasn't like a gangland shooting. This was an interpersonal, thing. So it's not clear, and there's no information. My adversary is asking you to make an inference based on the label Latin King that there are other antisocial acts, but there's no information on.
I think it maybe more goes to the fact that he is a functioning person. He's not, he's part of a gang. He buys a gun. He does there's nothing that one would say he didn't understand what he was doing. There's nothing here with respect to that.
The report does say that he has a lot of trouble understanding.
He never said, I didn't understand what I was
He didn't
doing.
have an obligation to take the stand. He didn't.
No, even on his pre-sentence report, he said nothing.
He's somebody who has a lot of verbal issues.
Okay.
A lot of verbal processing issues. And also, there was not before anything about Latin King. That was never proven at trial.
Okay.
That was not at all before the jury. So,
Counsel,
but it's
your red light's been on a little while, so can you wrap it up?
Certainly, Your Honor. So, I mean, to give the maximum sentence of 25 years in this situation, rather than letting him meet the parole board earlier, and it's the parole board who's going to decide when he has a right and if and when he has a right to return to society, since it's a life sentence. So, if the court has no other questions, then I will rest on my briefs and respectfully.
You have a minute on rebuttal, right? Okay,
and I will
counsel.
return for that. Thank you.
Good afternoon, Your Honors. My name is Brian Wattoon. I represent the people in this case. Turning directly to the excessive sentence point, the maximum sentence exists for a reason. As I said in the brief, sometimes it's appropriate. This is one of those cases.
Speak up so we can hear you. Yeah.
The maximum sentence exists for a reason. Sometimes it's appropriate.
And why is it appropriate in this case?
In this case, the defendant, as Your Honors pointed out, it was not a heat of the moment sort of incident. This was an incident that defendant's friend instigated earlier in the night when everybody's out celebrating Christmas Eve into Christmas morning. It was a joyous time. Everybody on this block knew each other. This defendant, the victim
Didn't personally have any beef with the victim.
Exactly.
Right?
Neither
Essentially
this
a stranger.
Exactly, Justice Scarpula. Neither this defendant nor the victim was personally involved in the earlier sort of fist fight.
So then how do we take into account his lower cognitive ability on how do we take that into account? In what way?
Yeah, so part of the purpose of sentencing, among a few that the Court of Appeals in this court recognizes, incapacitation. There are plenty of people who have cognitive impairments, and to some extent or another, and not all of them respond to their cognitive impairments by taking a minor spat between two friend groups and deciding to take matters into his own hands and shooting an uninvolved person at point blank after plenty of time to reflect, and in fact going up and down the block and being told that the victim was not the person involved in this fight.
Doesn't that play into the whole argument that that his cognitive deficiencies played into it? Because if he's being told by the instigator of this whole situation that the victim, that's not the person, and he went ahead and did it anyway, doesn't that play right into the defendant's argument that because of his cognitive disabilities that this is why he acted?
I don't think so, Justice Rodriguez, and I don't think so for a few reasons. The cognitive disability didn't manifest in that he wasn't able to understand that Carlos Davila wasn't involved in the earlier fight. Everything in the record and from the trial evidence suggests that he understood and did not care. When Carlos was telling him, there's no reason for this to be—
That's a fine line, whether he understood and didn't care or he didn't understand it at all.
I think it is a fine line, but I think the record bears it out here. Because Carlos— I'm sorry, Your Honor?
I'll let you finish answering that because I have a question.
Okay. And the main reason I will say is that Aguayo, when Aguayo told defendant, you know Carlos, you've known him for a couple of years, he wasn't involved. Defendant said, don't be a pussy, forgive my language, but that's in the record, the exact quote. And then when Carlos himself was talking with defendant and saying, look, this doesn't need to be anything bigger than it was. And Carlos clearly knew something about defendant then.
So I'm going to move you on more in a different direction. Usually when we have an application or a motion or an appeal involving excessive sentence, we have a whole number of factors that are offered by way of mitigation. And they have to do with remorse, they have to do with programs while incarcerated, they have to do with changes that have taken place in the person's name. Is there anything in this record here? Because from what I can assess, this is a very skeletal presentation that's based on a diagnosis or a psychological diagnosis.
I would agree with that, Justice Gonzalez. I think it is a scant record. What we do have was the cognitive impairment was before the sentencing court ahead of time. So we know that Judge Clancy factored it in when she sentenced defendant originally, and anything that has happened subsequent to his incarceration, we have certainly no record evidence about it, just some allegations that aren't borne out by anything sworn from defendant, certainly, let alone anything that was in the trial record.
Counsel, we've spoken a lot about the sentencing and his cognitive deficiencies, but I would be remiss if I don't ask you. I was supremely bothered by the prosecutor's conduct in summation. The fact that the prosecutor went on to directly ignore the judge's order with regards to the missing witness charge, the fact that the prosecutor then went on, in my view, to attempt to shift the burden to defendant, then went on to inappropriately vouch for a witness. How can you argue that this defendant got a fair trial?
Well, I'll first agree with Your Honor that, and as we admit in the brief, the prosecutor should not have done this, especially after having been told by Judge Clancy. And
Right.
Judge Clancy
Judge
to
Clancy
her.
denied the application. He goes on to ignore it. There's an objection sustained, and then he did it again immediately thereafter.
Right. So again, I'm not here to defend that, and
Because you can't.
I won't. And
We
but
want
what I
to
will say,
acknowledge it out loud and on the record for the district attorney's office, right?
I acknowledge it, and I put it in my brief. We acknowledged it.
Counsel,
I think that part of what you say, sorry, just let me finish this.
Please.
Part of what you say is that there was a curative instruction given, and that's true. But you're not taking the position that you could just ring any bell and unring it with a curative instruction.
Of course not, but we do rely on curative instructions when they're capable of ensuring that the defendant had a fair trial. And Judge Clancy, who was closest to this case, had heard all the evidence and was the very judge whose directive to the ADA went ignored and really kind of flagrantly, as you say, contravened. She was closest to it. She felt that the curative sufficed rather than the more drastic remedy of a mistrial and a retrial, especially because the evidence here was overwhelming, given that 4 separate witnesses, none of whom had a reason to attribute this murder to
Makes you
defendant.
wonder, with such a strong case, why you would, as a prosecutor, why you would inject this unnecessary issue.
Yes, it was not only inappropriate, but it was gratuitous.
and outrageous and disrespectful.
Thank you very much.
Thank
You have 1 minute. Let me let you give it to you. So.
Thank you. Okay, in terms of that my client didn't understand what was going on given.
Counsel, why do we have such a skeletal record with respect to the 19 years that your client has been incarcerated?
Because we're limited to the direct record on appeal, but I do know that he's participated in
This is an excessive sentence application, essentially. Where's the mitigating information that you should normally give us?
Well, basically, first of all, concerning Dr. Frazier's report, there's tremendous there. And he's in programs that specifically address that in prison. He's been in those since he's been in there. But in terms of the heat of the moment, other thing that we were talking about, right before this happened, my client had said, let's go home. He agreed to go home. And then the deceased rushed up to him. And with my client's difficulties cognitively
Counsel, why
processing-
did he have a gun in his waistband?
I don't know that,
Doesn't
Your
that
Honor.
show some premeditation? He was on the block looking for someone, and then he withdrew from his waistband, like in Wild Wild West, and shot the person in the middle of the street with 4 witnesses. Doesn't that show some sort of premeditation? And also, since there's no remorse, which has not been explained on the record, how can you explain that?
Your Honor, in terms of a person who has trouble expressing themselves verbally and who doesn't understand, I mean, yes, I agree. I don't carry a gun either. I don't have a gun either, although there's a Second Amendment. I mean, I don't. But I'm saying in terms of understanding and having the correct intent. I mean, yeah, I mean, I just think it's relevant. Just in terms of the sentence, it's relevant to consider the individual before the court and whether somebody with this kind of and unable to, has a lot of difficulty expressing himself verbally.
Was the defendant a violent felony offender? I think he had he was convicted of, I believe, criminal possession of a weapon in the 3rd degree.
He did have a prior weapon possession. Yes, I'm not saying he should have a gun. I'm not saying any of that. But just in terms of being able to process, when you have a range, he's already done 16 years. To let him meet the parole board, any relief, to let him meet the parole board a little earlier, rather than give a person like this the maximum sentence of 25 to life, when you're dealing with somebody who has who's in the bottom 2% of intellectual functioning.
Thank you. Thank you both.
Your Honor. Thank you.
Tobon versus Turner Construction.
May it please the court, good afternoon. William O'Connell for the defendant appellant Turner Construction and MS Harrison. Your Honors, this is obviously a labor law 240 case where the motion court, in our view, improperly held that plaintiff demonstrated as a matter of law both a statutory violation and proximate cause. Some of these holdings were based in part on plaintiff's mischaracterizations of the facts. We submit that tribal issues exist on both issues. I'm just going to start with the scaffold surfing and just get that out of the way because we know it kind of dominates this case and skews even the analysis a little bit. But plaintiff admits that he was scaffold surfing. Almost every organization around deems it unsafe and dangerous. Even the industrial code section cited by plaintiff in this case prohibits scaffold surfing. So it's misuse as a matter of law. I don't think anybody really can deny that in this case. But
So let me jump in.
please.
So with respect to the fact that the plaintiff was riding the scaffold while a coworker was moving it and then fell off, does the fact that the coworker is moving, pushing, pulling the scaffold break the or affect the analysis of sole proximate cause that you proffer?
As you can imagine, I'm going to say no, and the answer is because in this case, plaintiff engineered this entire maneuver. He said, "Move me," when he was standing on the scaffold. So he directed somebody to move that scaffold. So this is plaintiff's maneuver, plaintiff's act, and he directed it, and he was the one who was injured because of it. So in my view, that's not a negligent coworker, which plaintiff had in his brief as a comparison and the Court of Appeals has ruled on. That's not this case. This case is, I'm gonna do something wrong because I wanna do it wrong, and I need you to help me, so do it.
So the record,
I'm sorry.
the record also says, there's testimony that this was commonplace and it was done to cut corners so as to save time. Does that cut into your analysis?
Well, it doesn't. In my view of this record is that similar to some of the labor law cases that were already argued today, that was an example of just conclusory stuff. Statements like, it was done open and notorious and all this sort of stuff. But there's no statement by a witness with a name to it saying that this was accepted or instructed. And that's why some of the words like directed in...
How about the plaintiff? Didn't the plaintiff testify this was a regular course of conduct during the whole morning? I think they were doing this for hours, right?
He did say that. He did say that. But in order to say that this is either instructed by or approved by, you have to have actual evidence. You can't just say everybody must have seen it. We've seen it time and time again, plaintiff's side and defendant's side. That's not good enough in these kind of cases. And it's my position that we don't have it.
Direct instructions, is there any evidence that that your client instructed the plaintiff not to surf on this scaffold?
No.
To the extent that that was a policy or something that was known, it was provided during training, correct?
Well, there was training. I'm sorry. Let me back up. There was training, and it was in our health and safety plan. Mr. Abreu testified that it was in their plan and that they were taught no scaffold surfing. It can't be done.
So he can't be a recalcitrant worker because no one told him not to do this, right? That is basically what you need to show, that you were told not or given safety devices that you didn't use, or told don't do this and did it anyway.
I don't need to. Oh, I'm sorry, Judge.
In this case, neither one of those things. So he can't be a recalcitrant worker. Are you? And you're arguing he's the sole proximate cause of his accident?
Absolutely, that's what I'm
How about
arguing.
the scaffolding tipping? Isn't that the accident? Isn't that why the accident occurred?
Yes.
Are scaffolds supposed to tip?
Scaffold are not supposed to tip. And
Well,
when
if it
people
tips, isn't that a 240 violation?
Is that a 240 violation as a matter of law? Absolutely not. He is misusing the scaffold. That is banned by everybody, and by everybody in this case acknowledges
Isn't there some
it.
testimony that the scaffold could be outfitted with, I think it's called an outrigger that would prevent it from tipping?
There is some evidence of that, and that's in our company's health and safety plan.
This particular scaffold didn't have the outrigger.
It did not have the outriggers. But the question in a labor law 240 case is not, did it necessarily have outriggers, was the safety device,
was it adequate?
Was it adequate? That's exactly my point. And that's a tribal issue of fact in this case. We have the plaintiff doing something that is outlawed all over the place, and as soon as it was pushed, he fell, and he admits that.
Sir, does the issue of the question of misuse go to the adequacy of the underlying safety device, or to the sole proximate cause defense, or both?
Or both. It goes in this case both. I'm saying there was no violation here. There's a lot of record about the plaintiff's expert and our expert saying whether it was adequate based on outriggers. Our position is that it needs to be a stacked scaffold. I have the pages here, but you can look in the record. All the pictures show extended leveled scaffolds, big ones, not...
So it's your position that that this was adequate except for the fact that he misused it?
I'm saying it was adequate it was adequate, period, and he said that he never noticed any problem with it, but he was standing on it,
but that's
told me
not
to move it, and then he fell off it.
So it sort of goes to the for no good reason. It's the misuse sort of falls into the Bianconato element of for no good reason they didn't use it. He used it, he just misused it.
And in Bianconato and some of the Court of Appeals cases recently, that's been found to be a triable issue where there's evidence on both sides like there is in this case. I'm not saying that we should win summary judgment in this case. I'm saying that he was misusing it. Blatantly, everybody knows it, he doesn't deny it. But in this case, you have to compare that to what the other side says, and if there's a tribal issue, and especially on proximate cause, excuse me. I see my time is up. I'll do it on rebuttal. Thank you. You don't want to look at that.
May it please the court, Jesse Mink for the plaintiff's respondents. To address the main issue that was addressed in my colleague's argument, Mr. Tabone did not direct anything.
No, but he misused the scaffold.
Well,
he admitted it. He said, I didn't want to waste the time coming down and moving it.
Well, Judge, first off, the affidavit of his coworker is the evidence that there's no misuse that would raise a question of fact under 240. And if you look
Why? Why does that,
The reason is that Mr. Shemin said, we were demolishing, it's a humongous office facility.
Right.
They're doing section by section demolition of a ceiling. There's 4 scaffolds with crews of 2 guys each, one of which is the foreman. They're all doing this together for 3 days or so. Turner's got how many supers walking around, according to Juan Abreu, who testified? They couldn't miss this.
That's a difference, right? When we, I think it's curious when they say that he misused it. Because it's not like he went on the scaffold to just surf because he's having a good time, right? So to the extent that he surfed on this thing, instead of getting off of it and moving it, it was to save his employer time so he could do his job quicker, correct?
Well, yes, and that's the thing, that his foreman doing it, what that means is he's doing it, in accordance with an instruction. Everybody's doing it on the crew. They don't have to say specifically, get up there and surf the scaffold. If the boss is doing it, and that's the way we're doing it, that's the way he's doing it.
Who, if anyone, instructed or suggested to the coworkers that they move the scaffold while the plaintiff was on top?
They were all doing it the same way. Mr. Shemin says the same. This was the procedure. They had one man on the floor. The man on the scaffold takes everything off. They've got these special fittings for the arms.
But that's not the question. The question is, really, did the plaintiff instruct his coworker to move the scaffold?
In the moment, but to isolate.
So is that, yes?
Well, yes, Judge, but there's a but. The but is that to isolate in the moment when he says, move me, that's saying I'm ready to go to the next section. I'm done. That's not the same as directing the whole operation. The foreman is there. The foreman tells them, this is how we're going to do it. We're doing it for days. By the time of the accident, they'd been doing this for days. There's really no question to
That is certainly a reasonable interpretation of the plaintiff's statement in that moment. But at summary judgment, aren't we supposed to view the evidence in the light most favorable to the non-moving party? And here that would be the defendant. And so is plaintiff's statement, move me, or I'm ready to move, is that subject to interpretation or to varying reasonable inferences? And in that situation, wouldn't we have to deny the motion?
I don't think so, Judge, and that's because of the way misuse is actually defined, the way that it actually happens. You go back to the Cherry case, which I cite that's as a comparison to what constitutes misuse. There has to be some action that the plaintiff takes that's against, I believe the quote I'm paraphrasing is something about they don't exercise the normal and logical response to a situation, meaning they do something that is so outside the norm that it essentially negates the safety device.
Does the owner deny that everybody else was doing this?
No.
At this time?
Nothing that says
the owner didn't say,
Juan
"I
Abreu just
walked-
says,
I
I never
walked
saw it, and therefore it didn't happen. That's not the same as saying, I was watching them and they didn't do this.
There's no evidence to contradict the plaintiff's testimony that they were doing this for days.
No, and more importantly, nobody contradicts Mr. Shemin. He's independent here, and it lays out even more than the plaintiff did.
There was no OSHA violation or citation issued after there was a site visit. How are we to evaluate that?
Well, the courts, this court and the Court of Appeals have, if I can find the site, addressed that goes to industry standard or violations. 240 sets a higher standard than OSHA, and therefore if there's no OSHA violation, that does not mean there's no 240 violation.
So did I understand correctly that your expert witness stated that had this been outfitted with an outrigger, it would not have tipped over?
Absolutely, and that was, Juan Abreu said so as well. He
Okay,
said
but
5
even,
feet.
Even given that, the lower court did not base its ruling on the lack of an outrigger.
No, it didn't have to, because the flipping of the scaffold under Blake, there doesn't need to be a reason. If it flips over, that makes a prima facie. The burden shifts and they didn't meet theirs.
Well, usually we employ that presumption because the accident is unwitnessed or there's no obvious defect or prior issues or complaints with respect to the safety device. Here we do have a potential other cause, right? That is the quote-unquote subway surfing, subway riding, subway scaffolds surfing or subway riding. Different case.
Well, Judge, the reality is that under DeRose, Gallagher is a Court of Appeals case, that there has to be no good reason for him to do something unsafe. And here there is a good reason. His foreman is doing it. They're doing it for days. He's a worker. He is not in a position after days of this, when nobody has told him to stop, to question it. It's tacit approval by the GC. Nobody stopped them. Nobody says otherwise. You should sustain the lower court's judgment. Thank you very much.
Several of your honors asked a question about whether there was any denial. There was. Mr. Abreu testified that he did walk-arounds and was there all the time, and he never saw any of this going on. So that's not true, what counsel said.
So you're saying there's a credibility issue here?
Well, there's definitely a credibility issue, but I thought that right from the beginning.
So counsel, with
yes.
regard to recalcitrant worker, didn't the plaintiff testify that he was not told to not ride the scaffold? Isn't that the only evidence that we have?
Was it?
Let's talk about recalcitrant worker.
Except, if I may just interrupt, I'm not relying on that, but...
You're not relying on it?
I'm not relying
Then I
on
have
that.
no
I
question.
never did.
So then what your
It's sole proximate cause. They're similar but different defense.
Oh, I understand, but believe me, we probably do as many labor law cases as you do.
Probably more.
So you're saying he's the sole proximate cause because he was on top of a scaffold that tipped over when it was moved?
Absolutely, because he was not supposed to be, and it's industry-wide knowledge that if you're on a scaffold...
Is that enough industry-wide knowledge? Did anyone say to him, do not do that? Do you have any evidence of that?
Yes, I do.
Tell me what.
It's in this record that, I'm sorry, just like the question before where I vapor locked a little bit, but Abreu testified, or there's evidence, I'm not sure if he testified or if it's in his written affidavit, but that during their orientation, they were all told that surfing is not allowed. It's not permitted at all. And plaintiff, of course, challenged and said, well, we don't know that he actually heard that or that he attended that. And our witness said, well, everyone working at that site had to have been and gone to an orientation meeting or they would not have been permitted to work at the site. So it's our position that we've gotten all our facts out there and there's a tribal issue on certainly sole proximate cause or proximate cause. Thank you, Your Honor.
Thank you, both. Miller versus 22 Erickson owner.
Good afternoon, Justices. May it please the Court, David Salhenik on behalf of Petitioner Appellant Larry Miller. The Court's initial order on Mr. Miller's motion to discontinue made findings of facts which were largely correct. The Court rejected respondent's assertion of prejudice. That's page 7 of the appendix. The Court similarly rejected respondent's assertion of bad faith, finding that there was no evidence in the record to support that. The Court's initial order also did not find any frivolousness, and in fact, respondent didn't argue in his opposition to the motion that any of the claims were in fact frivolous. So those three factors were rejected or not found by the lower court. Nonetheless, when the court got to its decretal paragraphs, it decided to impose a punitive attorney fee against my client. Initially, in the initial order, that fee was for the entirety of the action, all three years of it. We moved to re-argument, and on re-argument, the Supreme Court granted the re-argument in part by reducing that fee from the entirety of the action to the fees from the date of appearance of the second counsel in the action, which was Gordon Reese Scully, now attorneys of record for the respondents. Although we appreciate, of course, that Supreme Court drastically reduced the fee amount, the Supreme Court did not go far enough. The reason why is because this court has repeatedly held that absent a showing of either bad faith, AKA malice, or prejudice, which is defined by the Court of Appeals in Loomis as a detrimental change of position, which we don't have here, and which...
Well, we start out with the court has discretion, right? And there are certainly plenty of cases that say you can't litigate a case for 3 years, then decide, or several years. Plenty of stuff happened, motion, practice, and then say, I'm going to discontinue, and you eat all your legal fees, defendant, right? The court certainly had the discretion to say, that's unfair. So where are we supposed to draw the line? Are you
Yes, Your Honor. This court has at least twice rejected that very argument. It did so in Laxer versus Bergen and Zager.
And we've also accepted that argument in plenty of cases, that that it is not an abuse of discretion for the trial court to condition a voluntary discontinuous without prejudice on the payment of some costs to allow the defendant to recoup some of its cost for litigating for 3 years.
Your Honor, we didn't find a single case where
Well, okay, I can show you a couple, but okay. Assuming that there are, where would you like, if you're saying that starting from the new lawyer is still not right, what are you thinking?
Okay, Your Honor. Justice Scarpula, that the Supreme Court relied upon a single case, which is Carter versus Howland Hooked Housing Company. It's a 2005 decision of this court. In that case, first of all, as we point out in our brief, and this is not disputed by respondents, there was a strong element in bad faith, because in that case, the plaintiff,
Okay.
yeah.
But we have our own independent discretion here, right? Let's all call it what it is. Your client, there was some indication that you're with a bankruptcy court that the lower court mentioned about your client, right? So we're looking at the same thing, and we have our own discretion here. This case is, and a new case bought derivatively, so your client doesn't have to put his own reputation on the line, is brought in another county, right? We're all seeing the same facts that you are. So again, where is the abuse of discretion with saying, sure, you litigated this case for 3 years, you have to pay something to ameliorate the effect of the defendant putting out 3 years worth of legal fees and documents, whatever else, to get it discontinued without prejudice.
Yes, Your Honor. I'd just like to put my cases on the record. In White versus National Bond Holding, which this court affirmed, the court, that was the argument. The argument was we had to litigate. The defendant said we had to litigate for several years. It cost us money. We should at least get that. Here's what the court said. Defendants may have been put to large expense in preparation of the contemplated defense of this action, but cannot be reimbursed thereas as a condition of discontinuance. This court affirmed that. And Laxer—
Right, reimbursed for all their costs. That
Correct.
was an all their costs case. This is not an all their costs case, right?
Correct, Your Honor. Well, in Carter, which is the case, again, the Supreme Court cited it was only the cost on the motion. And that's what this court affirmed and pointed out that was the correct thing for Justice James to do in that case, to limit it only to the fees on the motion.
But in those situations, we affirmed, right, the lower court's exercise of its discretion. Why shouldn't we give that same deference here and affirm the imposition of costs, limited costs?
Your Honor, this court has, as we point out in our brief, and we cite several cases, this court has not hesitated to reverse discretionary awards of attorney's fees where one of those three factors I started my argument with, prejudice, bad faith, or frivolousness, is not found. Again, the trial court, Justice Reed, rejected all those arguments, but still imposed the fees, and that's why we think it was an inappropriate exercise of discretion in this case.
Good afternoon. May it please the court. The court asked, where's the abuse of discretion? I don't think there is abuse of discretion. I don't think it could be found.
So let's talk about the delays that took place here, okay? So the actions commenced in January of '22, and the defendant files a motion to dismiss 3 months later in April, and that motion is denied. There's an application for a preliminary injunction in 2023 and that is denied. That was on behalf of, I believe, the plaintiff, if I'm correct. Then there's a document request in October of 2023, but there's a refusal by the defendant to provide any documents in January of 2024. Then there's a Rule 14 letter in February of that year, and then there's a status conference, and the defendant is directed to respond. But there's a whole back and forth, because in September of 2024, the plaintiff sends the court a letter and says the defendants refused to meet and confer as directed by the court. And then there's an order to show cause to withdraw as defendant's counsel in September of 24. So I need to understand why your client's counsel fee should be paid.
Okay, so all of the items that you just cataloged occurred before Gordon and Reese came into this case. The order was restricted. So initially it was all fees. It is now, on re-argument, restricted to when Gordon and Reese came into the representation. And that didn't happen until February of 2025. So all of those delays, all those things that went on occurred before and aren't part of the fee application. The fee application...
So 2025, you're saying that that's 2025 until now, right?
Correct.
But that's not 3 years' worth of litigation. That's 1 year's worth of litigation is what you're saying?
No, the case as a whole has a life of 3 years, but the current operative order restricts attorney's fees to when Gordon and Reese started representing the respondents, and that is February of 2025. So that's the order that we're dealing with here.
So can I ask you, what is the justification for you getting 1 year worth of legal fees when we have the American rule? What happened here that's special that would give you the right to attorney's fees when normally under the American rule we don't provide attorney's fees?
Sure. Well, I think, one, that 3217B allows courts to condition discontinuance on certain things, and that includes attorney's fees. There's cases to that effect.
Why
here? Here, we have we have a person, as Justice Scarpiola just mentioned before, who abruptly, for really no reason, there's no explanation as to why he stopped bringing the direct claims and brought derivative claims in Queens. So I don't think that we have necessarily positive evidence of good faith, but we have.
Was there bad faith that didn't the lower court, didn't Judge Reed specify there was no bad faith?
No. If you look at the opinion, it's very specific as to the part of the two-step process. The first part of the process is, should I allow the discontinuance? All of the findings that opposing counsel mentioned with lack of malice or anything like that, it's about should I discontinue or not. He said, no, there's no malice. If you look at the opinion's actually broken down the way that no prejudice or special circumstances to warrant refusal to recognize the request to discontinue this action. The malice is also in that paragraph with respect to discontinuance. The next part of the process is, should I condition the discontinuance on something? And the next part of the process is, yes, attorney's fees. It's not just needless, as the lower court wrote in his opinion. It was unnecessary to do this. So
We've added gloss, though, to 3217B. The statute says very broadly the court has discretion, but our judicial gloss is, as Justice Hagler was questioning you, there has to be a special reason why we're going to do this. We're not just going. We don't want the trial judges simply in their broad discretion conditioning the discontinuance on cost. There has to be a reason. Usually the reason is related to prejudice. Prejudice not just being costs you incur or frustration in defending the case, but some loss of a special right or some hindrance in your defense. And so were you prejudiced by their litigation conduct in the New York County action?
I think that there's a conjunction of two factors. There's the prejudice factor, which is having to defend an unnecessary action, and there's the lack of evidence of good faith. What we have is a stratagem to get a second bite at the apple. As the record shows, there was a preliminary injunction made in New York County. It was denied. Essentially the same preliminary injunction motion was made in Queens to get the same relief that was just denied in New York County. So you have a conjunction of two factors. I'd say that's not necessarily malicious, but it's also not evidence of good faith. It's a stratagem to take advantage of the procedural rules to get a second bite at the apple. So that, in conjunction with having to defend this unnecessary action, is sufficient evidence to allow, or I should say, sufficient evidence to condition the discontinuance on fees. There's sufficient evidence in the record that Justice Reed could take the action he did. So that's why there's no abuse of discretion, because it's sufficient.
Thank you. Counsel?
Thank you, Your Honor. Just to address the issue of bad faith, that argument was made both by respondents in this case and by the defendants before Judge Graves in Queens. Judge Graves rejected the argument in Queens, and Justice Reed rejected it here, finding that there was the court will not presume that petitioner seeks discontinuance with malicious intent. Malicious intent was the argument that we're trying to get a second bite at the apple in Queens, which was the argument in the papers. One other point, two other quick points, if I may. First of all, we cite Condor Capital Corp. It's a second department case. Obviously, that's not this court. But there, the court rejected fees and reversed after 7 years of litigation. The second department said, absent prejudice, after 7 years of litigation, the award of fees, or was a referral to a referee for fees, was improper. I'd also like...
That's a different litigation, right? There's no second litigation. There was no second litigation in that case. There was no idea that this was a strategic decision to get in front of a different judge with a better claim, which is clearly part of the calculus here.
Your Honor, there was no such finding, and
I agree there's no such finding by Judge Reed. He didn't specifically say it.
And Judge Graves in Queens.
Right. Well, I don't know. I have no idea. Judge Graves' decision isn't in the record. I have no idea, and it's not part of our record. But I agree that Judge Reed didn't specifically say that, but he did allude to the circumstances that caused you to seek discontinuance, and we looked at it too. We have the same discretion as the Supreme Court, right?
Yes, Your Honor. The second point I'd like to make quickly, if I may, is that Your Honor referred to the 3 years of litigation. As the record, it's clear, and their brief doesn't really dispute this. It was caused completely by respondent resisting discovery over and over again. We never got a response to our document demand served back in 2023, and there was a 5-month delay in the new counsel where they strategically had their counsel write to Judge Reed but not appear for 5 months, which earned them another 5-month delay. So any delay in this case, frankly, was caused by respondents purposely. Thank you, Your Honor.
Quick questions. Did the respondents file an answer to the amended petition?
They did not, Your Honor.
Have there been any depositions in the ongoing?
No depositions were held. We never got a response to our discovery. There were no third-party depositions. Virtually no discovery.
You made a motion for a preliminary injunction, which was you lost. Every motion you made, you lost, right? Yes. Every motion you made in this case, you lost.
That's not correct, Your Honor. We made a motion for leave to serve the amended petition, and that was granted.
Okay, fair enough. Yes. But all your substantive motions, you lost.
I don't recall, Your Honor.
And their motion to dismiss was denied?
Their motion to dismiss was denied.
Okay. Thank you both.
Thank you.
Alma versus Summit Glory Property. Oh, this time you're moving the chair over. Okay, fair enough.
Good afternoon. May it please the court. Patrick Lawless for the appellant or respondent, Linear. The Supreme Court erred in denying Linear's motion, that portion of Linear's motion seeking contractual indemnification against Momentum. Momentum was the only data cable installer at the site at the time of the accident. We have witness testimony saying that the drag line, which allegedly caused the plaintiff to trip and fall, came from one of the troughs for the data cable, and that it came from the troughs and that there was data cable hanging in that area. Momentum doesn't deny this. They just state that it wasn't their drag line. Drag lines are used to drag cable through areas such as this. This isn't a case where it's just, in the vicinity.
There's no doubt that Momentum owes you contractual indemnification.
Contractual indemnification, correct.
And you're arguing that we should grant it.
Correct, because it arose out of Momentum's work.
And there, right, there's no doubt that that work was, it was the drag line, he fell over it. It was during doing that fancy work to get in power lines for the computer equipment, whatever it was, right?
Correct.
Okay.
Correct. And that was the specific area that Momentum was doing its work. Again, they don't deny that it was their cables. They just maintain it wasn't their drag line, but it's still in their area. It's still emanating from the trough where the data cable was. So based on that, Linear should have been granted contractual indemnification. The other issues are the 240 claim as asserted against Linear. There's no evidence in this record that Linear had any authority to supervise any of the work being performed. Linear had contracted with Momentum, but if you look at the contract with Linear and Momentum and the testimony, at most, Linear had general supervisory authority.
Well, isn't that enough?
No, not just general supervise. They have to supervise and control the work and be responsible for safety. And this court and other courts have repeatedly held general supervisory. When I say general supervisory work, I just mean to make sure that the work is progressing according to plans, that it's being performed in accordance with the plans and the drawings, and that it's on schedule, but they didn't supervise and control the manner in which the work was performed. That was left up to Momentum. They didn't supervise the plaintiff's work, so they couldn't be held liable under 241. And as for 200, again, they did not supervise and control the work. They're only being held vicariously liable for its subcontractor's work, but they didn't supervise and control, and they clearly didn't have any notice.
How about dangerous condition? You talked about means and methods, but isn't there case law talking about you have to meet your burden showing you didn't have constructive knowledge of the drag line being in that position?
Well, Linear wasn't even at I don't even believe they were at the site that day. I believe they only were at the site once a week just to check on the progress. They weren't there on a day-to-day basis. And even in that case, the
Didn't you have a contractual obligation to make sure the work was done?
This is the thing. If you look at the record, the only contract, there's two contracts. There's the contract between Linear and Walters, and that just has to do with indemnification and insurance obligations. It says nothing about the scope of the work or what Linear is responsible for. And then you have the subcontract between Linear and Momentum, and that places responsibility on Momentum to be in charge of how the work is performed, and Linear just has general supervisory authority.
But you had the contract that you had with the owner, or the tenant actually, provided you with that authority and that supervisory control. You then subcontracted out, so you had the initial burden and responsibility to make sure it was done in a safe manner.
The only contract that's in this record between Walters, the tenant, and Linear is the insurance indemnification, and that mentions nothing about its obligations in the work and what it's supposed to do. It just mentions about purchasing insurance and indemnification obligations. It doesn't really go into the scope
Why
of
did
the
you
work.
subcontract it out if you didn't have that obligation? Doesn't it make sense that if you're subcontracting out some work, that you had, let me finish please, that you had an underlying responsibility to do so?
I understand that that Linear was contracted to do this work, but the scope and the responsibilities have never been spelled out. Thank you.
Good afternoon. May it please the court. James Walsh on behalf of Summit, Fossen, and Benchmark here. The first thing I'd like to say is just set up who my clients are very quickly. Summit and Fossen are ownership entities, and Benchmark is a general contractor entity, but did not have contracts with Linear and Momentum. They had separate contracts. I'll start by saying I think Linear just made my case for contractual indemnity against them very clearly. The contract they entered into with Walters contains a very broad indemnification provision. And what it says, there was a small error in the agreement. It says indemnities include all parties required to be additional insureds as per the statement below.
Is Fossum and Benchmark mentioned in that contract?
Fossen is, Benchmark is not. Summit is as well, because instead of being listed below, it's listed above. We think that's a small difference, but I would also say Benchmark is clearly an agent of the owner under these circumstances and entitled to the protection of that. Council also made the point, which I won't belabor, that this was very clearly a data cable coming out of a data trough. The contemporary witnesses who were there, the plaintiff, Mr. DeCourcy from Forest Electric, both said it was coming out of a data trough. It was clearly a data cable. The electrician said, we do not touch data cables. And these were even separate contractual lines. So clearly they weren't touching somebody else's work under those circumstances. Benchmark's employee came over later and confirmed that, and that's what's written in all of the accident reports.
So you're arguing that you're entitled to indemnity from Linear based on the Linear tenant contract, the
Correct.
Right, okay, not the Linear Momentum contract.
No, I'm arguing I'm entitled to contractual indemnity from Momentum as well. I guess he's over there.
Okay, well, that one, you're entitled to, are you named in that contract?
Oh, we are not, but the owner is, it says the owner.
And the owner in that context is the tenant, Walters Kluwer, right?
Except if you look at Walters Kluwer contract with Linear, they signed off as the contractor / tenant. There's only one owner of this building, and the owner is...
Yeah, but I mean, we have to construe the contract according to its terms. You're not named as an indemnity, right?
We're not named as an indemnity, but we are the...
You're not, there's no proof that you're the agent of the indemnity who is named, right?
But we are the owner of the building, and the word owner is specifically used in the contract. And Walters Kluwer, I searched everywhere, does not...
In that contract, isn't the term owner referring to Walters Kluwer?
I don't believe so.
I think it says Walters Kluwer in that contract.
It does not.
Okay.
It does
Who
not.
do you think it says? Who's defined as the owner?
The owner is undefined in that contract, as far as I'm aware. And to me, the owner of the building, just by common interpretation of what the term owner means the person, the party that holds legal title to that property. And that would be Summit and Fossen under the circumstances here. Oh, if I could just very quickly address the negligence and 200 claims were not dismissed against...
Yes, you have time.
...against the owner and Benchmark as well. And we submit, as to the owners, it's very clear they were not on site. So they had no notice one way or the other, actual in terms of a defective condition. They weren't on site, so there's no constructive notice as to them. To the extent it's a means and methods case, I mean, they're the owner. They were not exercising any control over that. In terms of Benchmark, it's already been established this was a separate contractual line. There was no control over Linear and Momentum in terms of their work. Benchmark was controlling forest entities. So we feel that the negligence and 200 claims should have been dismissed, establishing the predicate for full contractual indemnity.
Well, what did you put in to show your lack of notice?
Our lack of notice, we have the owners who said they were never on site and weren't there.
Is that enough to show your lack of notice?
How can they have actual notice if they were never there?
How about constructive notice?
How can they have constructive notice if there's nothing in the record to show how long this condition existed at all? Momentum played a lot of games. At first they said we were not even on site, and then they had to backtrack from that. And now they're trying to say they weren't on that floor. But when directly asked, their witness said, I wasn't there. I was only there once a week. I don't know what floor they were working on. The one thing we do know in the record in terms of open...
Well, I'm saying it's your burden.
Correct.
Right? It's not enough to say plaintiff didn't show how long the condition was. That would never meet your burden.
Well, that's correct, and I'm getting there, Your Honor.
Okay.
Benchmark did daily walkthroughs of the site, and they said we never saw any such condition. And that's why it's important that there's no evidence for how long it exists. It's not like it's a hole in the floor that was there for 3 days, and then you say, well, we didn't see it, so there's no... This is a transient type condition, And they said, we did daily walkthroughs and we did not see it at all.
Okay.
So I will finish up. Thank you, Your Honor.
Okay, we have one more. Paul Golden? Yeah.
Good afternoon. My name is Paul Golden. I'm representing Triram LLC, doing business as Momentum Data. My client presented the evidence that it did not use that drag line. It produced a number of pieces of evidence. One of them was that it does not use that color of drag line. In fact, the attorneys for Linear in their papers indicated that Momentum would not have used that color. And in fact, in their own papers, they indicated specifically that Momentum would not have been the party that would have caused the accident. They had that in bold, they had that underlined. Momentum is not the party that caused this accident. So one is we have the color. Another one is that the president of Momentum explained how they handle drag line. He said specifically, this is not how we handle it. Once we've taken the cable out, we cut away and we get.
Who testified at the Liberty job that they did not use this type of?
That was Mr. Bradley would testify. First of all, he didn't.
I think he didn't. He said he didn't know. He was not on site during the cable pull and had no personal knowledge of what was done at the Liberty job, right?
Well, what he said, first of all, he put into his affidavit that they wouldn't have used that color.
Yeah, but if you're not on that job and you have no personal knowledge, I don't know how much value you're saying we never use that kind of wire or that kind of drag is.
Well, he explained how he came to that conclusion as well. First of all, as I said, it's Linear itself, which also indicates that Momentum would not have used that color.
Well, let's talk about the cable, right? Your guy says that they definitely used, it was their cable. You pulled the cable. There's no doubt about that, right?
There is a doubt about that. That has not been 100%. That has not been yet established. In fact,
did anyone dispute that Momentum pulled the cable?
That particular cable. It's not that we're disputing that we pulled cable.
So you pulled the cable.
We
It's
pull
just
cable
the
in
drag.
general. Sure, we do. I'm not obviously I'm not disputing that we pull cable. What I am saying is an issue of fact is that whether this particular configuration was particularly
well, no one got
Momentum's
summary
work.
judgment here, right? No one got summary judgment. So yeah.
That's absolutely true. So
yeah, you're saying there's an issue of fact.
Well, that's I have to play both sides here. Obviously, my first reaction is one reaction is that definitely summary judgment should not be against Momentum, especially when Linear says that we weren't causing it, and also because there's a dispute about who left that configuration there. But leaving that to the side, all the evidence shows that this was not this was not the color.
You're saying that that's you pull the cable, but somebody else came along and pulled the drag line?
First of all,
did anyone testify to that?
Just to clarify, we're not admitting that this particular configuration was something that we had put up there. But even assuming it was,
I think we have to assume it was. Everyone agrees it's your cable. Even you.
No, I
agree
don't believe
it's
there's
your
been any
cable.
testimony saying this particular work was done absolutely positively by Momentum.
Okay.
But leaving that to the side, as I said, Mr. Bradley also explained that they always cut this. So what do we have on the other side after you have Linear saying, well, we didn't give them this color, and if we have Mr. Bradley saying we would never leave it in this condition? What do we have left? We have speculation on the other side. Maybe they would have run out, and maybe they would have taken someone else's, and maybe they would have tied it there or put it there, even though that wasn't their standard operating procedure. But once my client has produced all the evidence showing that they wouldn't have done that, and it wasn't the cable they would have,
But
drag line
that's
they would have
all
used.
speculation because nobody who had actual knowledge said that.
Well, the Linear certainly said it, and my client also explained that they would not have used that. He said that.
No, in a general way, but the guy who said that wasn't on this job. Where's the
because
guy
he
who
wasn't-
was
just-
on this job?
Just because he may not have been sitting in every single day on the job doesn't mean that he doesn't know what was used. And when Linear is the only one that handles, and they said, like, we only take whatever Linear hands us. Linear hands us this, they order it, we don't order our own. Okay, we'll take whatever Linear gives us. I think I'll have to leave the rest for my reply. Thank you.
Rebuttal? Okay.
Good afternoon. I'm Brett Hupart. I represent the plaintiff respondent, Nick.
You have a lot to respond to, so. go ahead.
Okay. Well, may it please the court. Before I get into just the details, just in general, what we're presented here today with is a lot of material issues of fact. There's a lot of interpretations of the facts, but as was pointed out in an earlier case today, it's to be read in a light most favorable to my client as the opponent of summary judgment. Momentum just was talking about they didn't pull that cable. Well, Mr. Bradley, the president of Momentum, said exactly because we pulled that cable. He identified it. It's right there. He also, when he talked about the color of the drag line, he said, my attorney has been saying that what the color of the drag line was. That's a whole red herring. Also, Momentum has been saying that that they don't borrow the drag lines, but Mr. DeCourcy of Forest, non-party to this case, said Momentum borrowed Forest drag line. These are all facts in the record. Now, Momentum has been arguing in their brief that they should be seen in a different way. They want to argue the interpretation. Well, you could argue the interpretation, but as the opponent of summary judgment, it all falls in my favor. Even though I think just by common sense it falls in my favor anyway.
One of them had to have pulled the drag line and the cable, right?
Well, it is
Either had to be
undisputed that one of the
Linear or
data
Mo- or
contractors.
Momentum or Linear, I think Linear and Momentum were the two that were doing this job, right?
Yeah, Linear was the contractor. It is undisputed by the parties that no one but a data contractor would pull it. And if we're going to talk about more of this interpretation and light most favorable to my client,
So how do
Linear
you,
admits.
may I address,
Sure.
how do you keep in the owner who says, I had no notice of this, it's a 241-6 case, right?
Yes.
So how do you keep the owner in?
Well, the owner didn't make a motion for summary judgment on 241-6. They're implicitly, you're talking about the owner of the building, correct? The owner of the general contractors.
Right.
They didn't make a motion for summary judgment based on 241-6. They're just basing the motion for summary judgment on Labor Law 200 and general negligence.
Oh, I'm sorry, so, yes, so how do you keep them in, I misspoke, under 200?
Okay. Well, how to keep them in under 200, it's basically Mr. Seeley, who is, well, this is the general contractor for Benchmark. Aside from the extensive provisions in the contracts that make Benchmark and even the owners responsible for safety, and there's some pretty heavy onerous provisions about how they're fully responsible for job site safety, Mr. Seeley from Benchmark, he makes it clear, he does his daily walkthroughs. He is never at his desk. He's always walking through the site. He's the one that made the subsequent remedial measure to correct this once he sees it. And importantly, he said, had he seen it, had he known about it before, he would have done it then.
But don't you have to show either actual or constructive notice, or how did that, so counsel says we've shown lack of actual or constructive notice. What do you say to that?
Well, I could either show actual constructive notice or the means and methods.
But it's not your burden, it's their burden. So what they say they showed it, do you agree?
No, I don't think they prove anything about that. It's, I believe I have a citation in my brief about that, about how they didn't meet their burden, and I'm not sure if it was just to them or if it was to one of the other appellants as well, that they didn't meet their burden to show they didn't. Yeah, everybody did move against me. In terms of how to keep Benchmark in, it's not just notice, and they would have constructive notice because this condition did exist there at least at the very latest from the day before. That's Momentum's testimony about the work was done, that the accident was on the 16th, the work was done no later than the 15th.
Nobody was
or
doing that
before
work on the 16th, so whatever had that hang down had to have been at least since the night before.
And if he does his daily walkthroughs, Mr. Seeley, he should have seen it. And if he didn't see it, he's remiss that way, and that's constructive notice. In terms of means and methods, the Rizzuto case is very instructive here because it says that a person, if they would be liable under means and methods if they have the authority to control it or to correct it, to correct an unsafe condition. And that's what this gentleman did, Mr. Seeley. He corrected the unsafe condition, albeit after the accident, but he said he would have done it before. It shows that he had control of that site. He was responsible for the safety. He's Benchmark. They're there together. He represents Benchmark. It's his site. He ensured the safety of this site. The evidence is very clear. It's everybody piles on saying that Benchmark was ensuring the safety of this site. As for the owners, if you want to separate them out from Benchmark, there are provisions, I do cite to it in my briefs, in the contracts, which should be good enough under Ross v. Curtis Palmer to show that they did have control over this site and control over the safety.
Well, no, because I think someone was arguing that they didn't have control. I think it was it Mr. Walsh? Were you arguing? Yeah, you were arguing that. So can you respond to I guess Mr. Lawless too, but let me ask for Mr. Walsh. How do you respond to that argument?
The argument that they don't have,
They only had general supervisory.
Well, in terms of, I already dealt with Benchmark.
Yes.
In terms of the owners themselves, it's a contractual. And that has been held good enough before the Court of Appeals that these contractual provisions will provide it. It's written in there for even the owners and not just Benchmark.
Even general supervisory is enough.
Well, I would believe so. And in terms of Linear, they're so involved with Momentum. They do everything for them. Like Momentum seems just to be the guys that actually have hands on it. But they're doing all the ordering, they're scheduling everything. They're in there, they're mixing it up. And by the way, to talk about Linear and admissions and about interpretation of testimony, Linear's witness does admit it was within the scope of their work to pull that cable by that drag line.
Okay, thank you.
I see my time is over. Thank you very much.
So, Mr. Lawless, you're first.
I'd just like to address Summit and Fosun's claim for contractual indemnification against Linear. Counsel said, reading that contract, it doesn't specifically say that they are to be indemnified. It says the additional insureds listed below. The only party that's listed below is Walters. He's referring to a prior provision about purchasing insurance for those parties, but he's asking, counsel just says, oh, it's a mistake, but indemnification agreements are supposed to be strictly construed, and any ambiguity is to be read against a party seeking to enforce it, and at the very least, this is an ambiguous provision. Unless you have any further questions, I'll rest on my brief. Thank you.
Now we have Mr. Walsh.
Yes, Your Honor. Very quickly to that last point, I would say, while it's not listed below, it is listed above. Names are actually used. They are
In one contract, but in one, you're not listed at all.
No, well, I'm dealing with them one at a time, Your Honor. Okay. And Linear's counsel just spoke. I think I made my argument on the other one, and that wasn't addressed, so I won't go back to it, but I think the word owner is sufficient. But as to Linear, it is listed above, and it tracks exactly what that indemnification provision says. It says the parties required to be named as additional insureds. And in that other provision, it says additional insureds, Summit, Fosun, and their agents, and it's very clearly listed. Just to respond very briefly to plaintiff's comments, one, I would say the case law is actually very clear that general supervisory authority is insufficient to constitute supervisory control. That's the Hughes case from the First Department. We cite several cases on page 10. And don't take my word for it in terms of the control that my clients exhibited. Plaintiff himself, who was a Forest Electric employee, said the only people who supervised him was his forest foreman. He never got any actual supervision from anyone else on the project. And just very quickly, one more point that I think is pertinent, and it is in the record. We do have on the site, Momentum ran out of dragline and ordered new dragline on November 16th, interesting day, and it did not get delivered to the site until November 19th. So this idea that there's no reason in the world as to why they were using red and white dragline is belied by the record. Thank you.
Thank you. All right. Now, Mr. Golden, you're up.
I'd just like to make a few comments. One is that it's not simply Mr. Bradley that made the comments that they wouldn't have used that. It also comes directly from papers from Linear where they put this in bold. There's no admissible evidence that plaintiff's accident arose from Momentum's work under its subcontract with Linear.
Well, somebody had the drag lines. It's either you or it's one, either Linear or Momentum, right? No one else was doing that kind of work.
Well, there were other people. There were other parties using drag
Doing
lines.
that kind of work with those kind of drag lines?
There were other. Linear's witness said that Linear's personnel did use drag lines to pull cables through the
on the
trough
16th floor to do to bring in that kind of stuff for the IT work? I didn't see anything. Who else was doing it?
They indicated that they used drag lines to pull cables through the trough system. And also, even Ulmer
No, on the
admitted.
16th floor for this type of work, right? Let's be more specific.
I understand.
Who else said that they were doing that kind of work?
Although the record may not show exactly who else may have been doing this work or not doing this work, there's been no admissible evidence that's showing that absolutely this was this
Well,
was
I
my
agree,
client's work.
right, but the
let me-
court below didn't grant summary judgment to anybody, right?
That's absolutely true. I also want to point out that Ulmer admitted that he and his coworkers from Forest Electric also did pull data cables themselves. So there was a lot of data cable pulling. And DeCourcy, despite what the plaintiff said, DeCourcy did not say that they saw anyone from Momentum actually use the orange or red and white. He said specifically, "I never saw it. I didn't see it." You can look through the record yourself. There's no testimony about that. All there is speculation. Maybe. There's nothing else besides that, and that's not enough to go to a jury.
Thank you. Thank you all. Judson versus Elliott Management Corporation.
May it please the court, my name is Jason Rosger. I represent the plaintiff appellant Glenn Judson. This is a New York City human rights law retaliation and discrimination case. This court has said numerous occasions that trial courts must be especially chary in granting summary judgment in such cases because the intent of the employer is at issue. In this case, rather than drawing all the inferences in the plaintiff's favor, the court below drew them actually against the plaintiff. For example, a jury would be entitled to draw the inference that because my client's immediate supervisor, Oleg Olodvyankov, had told a third-party witness that Mr. Judson should be replaced because he was not young and energetic, that age discrimination was a factor of his termination. In fact, the trial judge drew their own opposite inference because the person that received that message from Mr. Olodvyankov was actually older than the plaintiff. We cannot say as a matter of law that a manager's statement of age discrimination can be given no weight just because that statement is given to someone who's older than the
Counsel,
plaintiff.
isn't your argument contradicted by the ages of the players involved so that, for example, your client was 47 years old, his supervisor, Ms. Basu, was 57, the CTO, the chief technical officer was 51, the chief operating officer was 49, and Ms. Gorevich, who was assisted by the plaintiff in relaying the remarks that she had heard that are perceived by your client as discriminatory was 47. Moreover, the replacement from the plaintiff was 54 years old, so he was older by, what, 7 years?
The first thing to keep in mind is plaintiff is not arguing that Ms. Guervish was discriminated against because of her age, therefore he was discriminated against before her age. What our argument is that the decision maker told someone, I want to discriminate against Mr. Judson because of his age. Now, a jury is entitled to make the inference that that is evidence of age discrimination.
So you start, that's your first, and then the employer puts in evidence to rebut that inference, including the fact that nobody younger was hired, all the evidence so now it comes back to you.
That's not quite right where there is direct evidence of age discrimination. This is not the...
It's not direct evidence against you. It's just one stray remark is insufficient. Let's talk about, so let's assume that we're at the third step. What else have you put up?
I would say first, Your Honor, this is not a stray remark. This is targeted. This is targeted right at my client.
For the purpose of my question, that it's this one remark between two other people, and then the employer puts up the non-discriminatory reason and shows that all the other things that would normally go along with an age discrimination case are not met. So now, again, what else do you have?
I don't want to be disobedient, but we have evidence, and I'll get into this when I talk about retaliation.
Let's do retaliation.
The jury could also consider that, one, the temporal proximity, only 3 months, okay, in no particular order. Number two, that Mr. Olavianakad had expressed hostility toward individuals making complaints, and that they shouldn't be around and shouldn't be trusted. Three, evidence that the proffered reason of the plaintiff's performance on the CIO project is in fact pretext. There's not one contemporaneous document showing that Mr. Judson's job was in jeopardy because of his performance on that job. There is not one contemporaneous document showing why he was fired. All the evidence the court has about the reason for his firing was put down and created after this case was filed. I think it's also relevant that a jury could consider that the company was very dismissive and hostile toward the complaint that Mr. Judson passed along. The perpetrator of the complaint, Mr. Baton, was never even talked to until after my client was fired. And that was in the context of taking him out for a drink afterwards. So the jury was entitled to draw those inferences against the defendant. And in fact, the court drew them against my plaintiff.
So and then you have the third one, the hostile work environment.
What I would say on the hostile work environment, Your Honor, is that this is the city human rights law. The standard is if it goes beyond petty slights or trivial inconveniences, then it goes to a jury. No one over 40 in the workplace should have to hear from their boss that the workplace needs to get younger and more energetic.
But it has to be directed towards you, the protected class that you're in. Williams says that. It has to be directed to the protected class that you're in.
The remark of the workplace needs to get younger was directed directly at the plaintiff. That's on 774.
So that's one statement. But what you're alleging is that he was talking about women and Indian employees, which your client is not.
I think that's still, for any, decent human being, that's still a hostile environment. To know your boss considers not only age to be a acceptable criteria for judging people at the workplace, for him to be talking about, dark and loud pit bulls or getting rid of the Indians, that's going to create an atmosphere of fear and terror that your boss is a discriminator. He's not basing on people's merit. He's not basing decisions on...
But it has to be to you. has to be that that you are afraid that you are being discriminated.
I don't think that's quite the case, Your Honor. There are cases
I-
that
have
don't
you-
discuss
I mean, in Williams, that was clearly what the court said, right?
I would say there are other cases that take a more expansive view that were cited in my papers that
Let me-
the,
I'm sorry. Did you, that on the data management system that was used to, or the management of the data management system, was used as a critique of the plaintiff's performance, right?
after he was fired and this case was brought, correct.
Was anybody else involved in that project fired or sanctioned? Or,
No, there weren't, and that's in the papers.
and as to the delay, for example, was the project manager for the data management system reprimanded in any way?
There's no evidence in the record she was reprimanded. She did leave the employment, but Ms. Guervich testified about that. Can't give you the citation, but she was not disciplined or fired.
So that was, are you calling this pretextual?
Yes, of course, for all the reasons I stated earlier.
Wasn't there a November 2017 performance report which was favorable to the plaintiff?
I think it was December was when it was actually delivered to the plaintiff, but yes. And I discussed that. Every area was good or better. And he's there 11 years. To go from that to being fired in the matter of,
Well,
8 months.
his job changed, right, over that 11 years. He had a lot more responsibility. Okay, thank you. We'll get you on
Thank you.
rebuttal.
Sorry. May it please the court. This court's precedent fully supports the decision of the motion court to dismiss this case on summary judgment, even under the New York City's liberally interpreted human rights law. I'm going to start with retaliation. Plaintiff failed to establish even a prima facie case because the decision maker, the CTO, was unaware of the alleged protected activity, a May 2018 complaint, at the time of the August 2018 termination. That is undisputed in the record.
Well, the management was aware, right?
Management was unaware, but we have testimony from the CTO, which is uncontradicted. There's corroborating testimony of the COO, who was one of the few people who did know about the complaint, along with HR, who said he never told the COO. We have two senior deputies of the the CTO, who acknowledged they didn't know about it, and nothing contests this in the record.
But I guess the question that faces us is whether the complaint as a discrimination could be the quote-unquote extra factor that pushed the employer from dissatisfaction with the employee to actual discharge. And here, I mean, it's an interesting record because there were no complaints in writing. There was no warning as to your job is on the line. It wasn't indicated that he was hanging by a thread, in the words of Cadet Lagos. And there was no action taken against other people with respect to the data management system.
So he was the owner of the data management system. I know there's a project manager, but that's a lower level person who helps move it along. He was the one who was presenting at these back office strategy meetings. There was no head to roll above his on data management. In terms of the record, it is replete. Talking in terms of whether he got a specific written warning, maybe not. But if you look at the documentation, even the evaluation from 2017, it's got some favorable things, and then it's got some things that presage things like a November 2017 analysis of senior managers calling his deficits specifically. A meeting later on between the CTO and his boss and the head of HR saying, we need to restructure, this guy isn't cutting it, we need to organize this department differently.
So let me just start you with, there's no doubt that he performed protected activity. So he complained about discriminatory conduct, correct?
Yes.
And he's fired 3 months later, right?
That's true.
So there's temporal proximity, one, right? And even though the person who fires him denied that he knew that, that person had been reprimanded for making discriminatory comments, correct?
That is not correct. Okay, that you may misinterpret that from the argument or the pleading, but the individual, the CTO, was never reprimanded. The individual who sent the text, this Baton, who was mentioned by opposing counsel, is another person who sent a non-ageist text to a coworker, Elena Gurevich, who then came to Judson, the plaintiff, who then came forward.
You're saying that the COO didn't say anything to the person. There was no testimony that he was reprimanded by the COO.
Absolutely no testimony that the CTO was reprimanded by anyone because he was not the subject of Ms. Gurevich's, or this text that went to a third party. This relates to a different issue with another employee who sent an inappropriate text that then the plaintiff came forward with. The person who was reprimanded was the individual who sent this inappropriate text.
No, you're saying that the person who fired plaintiff was never reprimanded.
No, he was not reprimanded. He was not found to do anything wrong. He did not know of this, of the complaint. He's not an HR. The complaint came forward. It wasn't really about him.
He was informed by the COO within a week of the complaint
He really was not. The record is really clear on this. He was never informed. You've got the testimony. The person who was ultimately informed about this complaint is the guy named Alex Baton, who's separate, who sent a text about that is not ageist to another employee that was inappropriate. That was the person who was talked to. The CTO was never talked to. He didn't send the inappropriate text. He was alleged to have run a...
No, not the COO. Who is the person who fired plaintiff?
CTO.
The CTO. And you're saying there's no evidence that the CTO was reprimanded by the COO.
There is no evidence that the CTO was ever reprimanded. He didn't even know about the complaint until Mr. Judson left, and then his lawyer complained of age discrimination. That was the first anyone heard of age discrimination.
Okay, but all right. Yeah, okay. Thank you.
Can I make one last point on that? Because you mentioned...
We have a lot of people behind you, so...
I got it. Just
20 seconds.
Temporal proximity, you mentioned that point. That may be enough to establish knowledge. It may be enough to get you past prima facie. Once we've come forward with evidence, the burden is on them.
I agree. And what they say is your guy's the only guy who was fired. Your guy's the only guy who was fired. Everybody else who had complaints that they had complaints about, they weren't fired, right?
He was the top dog.
So that raises well, whatever. Okay,
Understood. Thank you.
Now, I have to get this clear. I thought that there was, no, I'm talking to counsel. I thought that there was evidence in the record that the COO was reprimanded. CTO was reprimanded by the COO. Counsel said absolutely not. What do you say to that?
Mr. Showett, the COO, testified that a week after the complaint that my client had passed on, he had a conversation with the CTO about professional communications, words of that nature. Now,
but he wasn't reprimanded. There was so.
And I don't know if Your Honor is thinking of this. After these events took place, Mr. Olivyanovkov was effectively demoted. He was put in a job where he's not supervising anybody. There's no piece of paper saying,
No, and no one testified. He did testify. I reprimanded him. I thought that's what you were arguing.
No, what I'm arguing is that the CTO had actual knowledge. There's circumstantial
well, that's
evidence.
What I'm saying. How do you know?
You know
he
because
denies it.
Sorry,
the person who fires your client denies that he knew that your client had.
And let me back up and explain why it's important. Okay, general corporate knowledge is enough to get you past step 2. Okay, and then we're at step 4 now. Is there an inference of discrimination? And then the evidence that he knew about it, that Mr. Olivyanovkov knew about the complaint, is put in the mix with every other piece of evidence.
But I'm saying, what evidence is there? There's none. He denies it, and you came up with nothing.
Oh, it's not nothing.
What is it that you've come up with?
He was told a week later, okay, about communication issues. I don't think we have to accept as a matter of law.
I don't know what you mean. That's so broad. What do you mean he was told about communication?
That's Mr. Showett's testimony of what the conversation was.
What page are you talking about in the record? Do you remember? I can look at it, but just tell me quickly if you remember it. No, it's fine.
Don't have.
You only have.
And the communication issue was from Showett's testimony. I don't think a jury is obligated to believe that's all that conversation was. 2, Mr. Oldknife is hostile to people who make complaints about retaliation. I'm sorry, make complaints and want to retaliate against them. So that's another point,
What
inference the jury
evidence
could
of
draw.
there was it that he was hostile to people who made discrimination claims?
Well, non-party Lunan Peck testified that Olaf Yanikov told him, this other person made a complaint, we can't trust them, we got to get rid of them.
Okay.
That's relevant. That's something that the jury could consider.
Okay. Thank you. Thank you both.
Thank you, Your Honor.
People versus Campbell.
May it please the court, my name is Paul Wiener, appearing for Crafui and Campbell. There's no question that this was a very serious offense, but I would like to focus the court on the fact that, first of all, Mr. Campbell is severely mentally ill. Second, he was unmedicated at the time of the offense through no fault of his own. And third, he expressed
Well, how do
extreme
we know it's
remorse.
of no fault of his own?
It's no fault of his own because this happened, I believe it was April 2020 at the height of the pandemic. And unfortunately, the nurse who would come in and give him an injection, he's severely bipolar, did not show up because of the pandemic. And he had a manic episode and this tragic incident occurred.
He killed a lady and left her in a garbage can.
There's no question that it's a very serious incident, and I know that whatever the court decides, he's going to get a long sentence. But I do think that the fact that this is somebody who had a very traumatic childhood. He was physically abused. He had little contact with his father. His brother was murdered. He was hit by a car, and then at age 12, he's diagnosed with bipolar disorder.
Let's start with the waiver. He waived his right to appeal, right?
He waived his right
What's
to.
wrong with this waiver? I have it here. What do you think is wrong with this waiver?
I think, well, first of all, I would say the fact that he is severely mentally ill.
Yeah, but I mean, the mentally ill people live in our society every day. What is it that you have that this person on this day didn't understand what he was doing?
I think also the fact that, he didn't even complete 9th grade, and I've cited cases. He has a very, very limited education. I just don't think we can assume that he would have understood the complex nuances of this appeal waiver, whether it's oral or
Was
written.
his capacity, was he 7-10-30'd?
I'm sorry, what?
Was he evaluated for
He was twice.
mental capacity?
On 2 occasions, and he was found to be fit. But given his very limited education, I mean, look, at one point the court says,
So are you arguing that because of his limited education and whatever his struggles are, that there are no circumstances under which he could have understood the waiver, or are you saying that the waiver here, as delivered, was bad?
I'm saying there are some problems with the waiver.
What are they?
First of all, at one point the court says, just uses the word separate and distinct, but doesn't explain until later what rights were forfeited automatically. I also think that the court incorrectly suggested that the appeal waiver extinguished the right of the assignment of counsel. But
I looked at that one in particular. The question was, do you understand that the right to appeal, if you exercised it, would have allowed you, with the assistance of an attorney, to have a higher court review the conviction, right?
Mm-hmm.
Okay, that's literally taken from the model colloquy that follows People v. Williams.
I think, Your Honor, look, it's it's nuanced, and I don't think we can and we should apply exactly the same standard to somebody who didn't even complete 9th grade, who is severely mentally ill. I mean, I have to read these things 3 or 4 times, I'm sure Your Honors do as well, to get all the nuances and the complexities, and I think, that we can't assume that he just understood all of this.
Even though he said he did?
He said
why would he lie?
I'm not saying he lies, but that doesn't mean that he really did understand this. Again, I've cited all these cases.
That's a serious problem, right? Because if you ask a person if they understand and tell you yes, what are you supposed to do with that?
But he's poorly educated. He's had bipolar disorder since.
What I don't understand, counsel, is this. I think a lot of us have represented mentally ill clients, and when there is a problem, you address the court directly and say, Judge, he may have gotten through two psych evals, but he's not understanding me. He definitely doesn't understand this. This person was represented by counsel.
Right.
So what do you make of that?
I just, like I've cited, I think it was on my reply brief on pages 7 and 8, I've cited all these cases where other individuals who have had this level of education and this sort of mental disability, these appeal waivers are viewed very differently, and we just don't assume that they understood all the complexities and the nuances. I just want to emphasize, this is somebody who, as a result of his bipolar disorder, he, as I said, he left school in his 9th grade. He's been in and out of mental institutions his entire life. He's been on all sorts of medications and stuff. And again, this is a situation in which the nurse who was supposed to give his injection did not show up. And I just think, and he expressed extreme remorse. If you look at the pre-sentence report, this is from the probation department. It said he expressed a lot of remorse. He felt terrible, responsible. He apologized not only to the victim, but to her family. He wished he could go back in time. He truly loved her. Counsel said that he evinced nothing but remorse throughout the pendency of the case, and the case lasted for over 3 years.
But his evaluators, and I said 7/10/30, but it's 7/30, said that they thought he was malingering, that he really wanted to leave the jail setting and gain mental health housing. What do we make of that?
I know that was in there, but I don't connect that necessarily to the fact that he has expressed extreme remorse. And again, remember, counsel's saying he's expressed remorse from the very beginning. In fact, there was even evidence that he tried to give CPR immediately after to resuscitate the victim. I mean,
I don't understand, okay. I don't understand that part. I mean, he dismembered her and then was pushing part of her around
And again, this
the
is
cart
very
as
serious.
well.
I know he
really?
deserves, he's going to get a long sentence, Your Honor. The question is 19 years for somebody who is...
He was subject to 25 to life, right?
He was.
And he had 2 prior violent felony convictions, right?
He did,
So
Your
don't
Honor.
you think the trial court adequately took into account his mental health issues by not giving him, which would not have been an unreasonable thing, to give him 25 to life after 2 convictions for violent felonies and the horrific nature of this crime?
I just think that it would be an appropriate sentence for somebody who wasn't mentally ill, who was not unmedicated at the time through no fault of their own, and didn't express remorse. I would agree with Your Honor, but that's not what we have here.
Didn't your client actually flee to Illinois? He had the capacity to flee after the incident. Isn't that true?
He did, and there's no question that he strangled the victim here, and there's no question that he panicked.
He fled.
But that doesn't mean, again, there's so much evidence, and it's coming from the Department of Probation that he expressed remorse here. Thank you so much.
Thank you.
May it please the court, Lindsay Richards for the people. Good afternoon, Your Honors.
We can leave the waiver, or maybe someone else wants to argue. I just want to know, do you think the trial court adequately took into account what is absolutely undisputed, that this man has mental health issues?
Yes, Your Honor, and I do want to touch on that as well as counsel's involvement in terms and awareness of the defendant's mental health history. This defendant did have a documented mental health history. There was substantial 730 litigation that went on during the pendency of this case. In fact, defense counsel moved to controvert the findings of fitness, and 2 additional doctors were hired, evaluated the defendant, and those were the doctors that found that the defendant at times appeared to be malingering or exaggerating his symptoms in order to get a transfer from the facility where he was being held. But that being said, there was a long process over the 3 years that this case was pending, where the court, defense counsel, everyone was very aware of this defendant's mental health issues. And in fact, even at the time of the plea, the judge took time to explain to the defendant that his chambers had spoken with the facility where the defendant was being held to ensure that he was receiving the mental health treatment that he needed, that he was getting his medication, that he was being held in the appropriate place as opposed to general population.
He was in a psychotic state when he committed the crime?
No, Your Honor. There was a psychiatric defense was never pursued in this case.
That's why when you know, this idea that he committed the crime because he was unmedicated, That wasn't pursued, was it?
He never raised a psychiatric defense or served notice of a psychiatric defense. There was the 730 litigation relating to his competency, but there was certainly no suggestion at the time where this case.
Counsel spoke a
Yes,
lot
Your Honor.
about the defendant's remorse, but at the time of sentencing, the defendant remained silent, correct?
That is correct, Your Honor. He expressed no remorse to the victim's family or to the court at the time of sentencing. And I think because counsel was so involved and so aware, as well as the court, of the defendant's mental health history, it's very clear that the defendant understood and everyone was sensitive to the fact that this history existed in ensuring that he understood what he was doing when he pled guilty and when he waived his right to appeal. So the people ask that Your Honors affirm the judgment of conviction and the sentence. Thank you.
Thank you.
Just a couple brief points. You know, his sentence again is 19 years, which is almost double the minimum sentence. And I'm not even.
I mean, this is his third violent felony, and he murdered and dismembered the victim.
Yes, Your Honor.
I
and
mean, if that doesn't,
he deserves a long sentence. But again, this is, you know, if he was like a total if he wasn't mentally ill,
okay.
if he
So
was
let
a
me.
sociopath,
Did he raise a psychiatric that he was not guilty because he was in a psychotic break at the time he committed the crime?
But counsel.
I'm asking you, did he raise that?
That wasn't he.
Okay.
Well, he pled guilty before they went to trial. But
No, I mean, but you have to raise it at some point. Did he raise it before he pled guilty?
I am not sure to that, Your Honor.
I don't think.
But,
Well, there was nothing in the record that indicated he did, right?
but what was in the record was that counsel said, and it wasn't disputed. Nobody's disputing this at all. That the nurse who was giving him his antipsychotic medication did not come because this was.
So what do you want from us?
I'm sorry?
What do you want?
I would say 14, I think is appropriate. Thank you.
Thank you. DeKalb County versus Galan.
Good afternoon, Your Honors. Tom James on behalf of plaintiffs' appellants. The lower court erred in dismissing plaintiffs' claims arising from the unfair squeeze-out merger of Avangrid's minority
Counsel,
stockholders by its
I
control.
can't really hear you.
Oh, I'm sorry.
Yeah, thank you.
Is that better?
Maybe pull it closer to you.
Yeah.
Sure thing. Of Avangrid's minority stockholders by its controlling stockholder, Iberdrola. In these circumstances, New York law recognizes that controller transactions like these pose an inherent conflict of interest, and a controlling stockholder can only avoid searching judicial review.
No, I mean, we know what the
Yes.
standard is. Why don't you just go through the conditions that you need to show?
Sure. Starting with the first condition, Kenneth Cole required Iberdrola to condition the merger at the outset and irrevocably on a majority vote of disinterested Avangrid minority stockholders.
Well, they had a committee, right? They had a committee, and they had a vote of the minority stockholders, right?
They had a vote. They had a vote pursuant to a stockholder agreement between Iberdrola and Avangrid. That was a different That was a different voting standard than what we believe Kenneth Cole and MFW require. Those cases require a majority vote of disinterested minority stockholders. What the shareholder agreement between Iberdrola and Avangrid required only excluded from the vote Iberdrola itself and entities that Iberdrola directly controlled. Now, what's interesting about that is that Iberdrola could have satisfied the shareholder agreement had it agreed to a Kenneth Cole compliant majority of disinterested stockholder vote ab initio, but it deliberately chose a different standard. Not only did it choose a different standard, but during the course of negotiations, this issue came up. There were drafts of the merger agreement traded back and forth between the special committee and between Iberdrola, where the special committee affirmatively raised the inclusion of QIA, the Qatar Investment Authority, in the minority vote. And what Iberdrola said at that point was no, they refused to exclude QIA from the majority of the minority vote. So if Kenneth Cole and MFW require two things, it is self-disabling at the outset, and it is not interfering with the majority of the minority vote composition during the course of negotiations, and that's necessary to create arm's-length negotiations and to protect.
What are you saying? Because QI, the subsidiary was in the minority group, that was what condition of Kenneth Cole, or are you saying that violated?
Sure. It was the failure to condition the vote on a majority vote of disinterested stockholders because, as we've alleged in the complaint and hopefully explained sufficiently in our papers, QIA cannot qualify as a disinterested stockholder in these circumstances for a variety of reasons. The primary reason is because QIA owned a
Doesn't it say the minority stockholders?
It says the minority stockholders, but
So where are you coming up with this? Where does this come from?
when you look at the trial court decision in MFW that was affirmed and then ultimately adopted
I'm
by Kenneth
asking you,
Cole,
where from Kenneth Cole does this come up, that minority has transformed into something else?
I don't believe it's a transformation of the minority into something else. The purpose of the minority vote serves a couple of purposes, but the primary one is that it allows stockholders to vote on the merits of the merger, the economic merits of the merger, as opposed to other collateral consequences or other issues. Disinterested is implied in...
Isn't there a case that discusses this matter of Baltic trading, which permitted that very circumstance to have QIA included?
So I think Baltic goes to a slightly different issue, which is one of coercion, but I'll address Your Honor's question head on.
It's not coercion that you're talking about?
Coercion is one of the elements that I believe that Iberdrola failed to implement.
Why do you believe QIA should not have been part of the minority vote?
Because QIA had economic reasons to prefer a merger that benefited Iberdrola at the expense of minority stockholders, not just because of its larger holdings in Iberdrola, but because it was Iberdrola's strategic business partner for over 10 years, because the principles of QIA and...
But that's exactly what happened in Baltic, right? There were the same thing, the same situation, and this court upheld that, or found that the conditions had been met. So there are a bunch of, let's move on to another thing, because I think Baltic, if you want to talk more about it, you can, but maybe we should move to something else.
No, I think it's sufficiently important to talk about Baltic.
Okay.
I think Baltic is distinguishable, again, because the coercion analysis and the ab initio analysis have to do with what the minority stockholders are voting for. Are they voting for a transaction that is in their best economic interests or some other reason? The allegations in Baltic were, I went back and read the complaint, they were scattershot. There were allegations that there were stockholders who owned controlling stockholder shares and target stockholder shares. But there was no allegations that would have given any suggestion why those cross-holding stockholders
I
would
think Baltic directly says, and I can quote from the decision if you like, but it says that in Baltic, that minority shareholder that was also alleged to have been part of the majority, that shareholder had agreed to vote for the merger, and we found that that was unavailing. So I don't know how you're distinguishing it.
I tried and perhaps unsuccessfully tried to distinguish it on the basis of incentives, right? To my knowledge and to my best recollection, there are no allegations in Baltic and nothing in the decision discussing why those stockholders in Baltic would be incentivized to vote for a merger that favored the interests of the controller as opposed to the minority stockholders. Here, you have a large stockholder with incentives to do that, but I take Your Honor's point.
Okay, thank you.
Good afternoon, Your Honors, and may it please the court, Andrew Ditchfield from Davis Polk and Wardwell on behalf of respondents.
So let me ask you, why include QIA in the minority shareholders if they're a subsidiary of the majority shareholder?
So first, they were not a subsidiary of the majority shareholder, an independent third party who's an investor in both the buy side and the sell side.
Oh, I'm sorry, you're right. They had both sides of the transaction.
They had both sides of the transaction, just like in Baltic.
Yes.
I agree with you. And yes, they're alleged to have had some strategic relationships with Iberdrola.
Isn't it true that they own 8.7% of Iberdrola, so they had a financial interest in making sure that the deal went through?
If that was true, Your Honor, then it can be squared with their actual conduct, which is undisputed, which is that when Iberdrola made its initial offer in March of 2024, QIA went to the unaffiliated committee and it said, objected, it said this is materially inadequate. There's no economic...
They asked for an increase in the price.
They asked for the seller to cause the buyer to pay more. If it were the case that their economic incentives were aligned with the controlling shareholder, that behavior makes no sense.
Let me direct you to another issue, which is the council says that the fact that the directors, the uninterested directors, were getting paid a substantial amount of money makes them interested rather than uninterested. How do you respond to that?
Sure. So I'm not going to argue with the idea that $200,000 is insubstantial.
No, we all thought we would like to sit on that board. If there are any open seats, we're in.
Well, we'll take that back, Your Honor. But I think decisions in the New York courts, including the Mack case, including the Blankfein case, have all said substantial director fees, but fees that fall within the range of ordinary course, are not sufficient to overcome the presumption of a director's independence under New York law.
And there's no indication that these fees were out of line with other companies of similar size and similar.
That's correct. I apologize for talking over Your Honor. That is correct. And I think
certainly if $200,000 was the number, then 80% of the country couldn't serve as an uninterested person on a board.
I think that's right, and I think the courts have recognized that. And if you sort of play it to its logical conclusion, the idea that $200,000 was so material that a director would put their own reputation at risk, to keep that would mean, in the context of an M&A transaction, that they would vote against the merger, because voting for the merger means that those director fees go away. I think what the plaintiffs are saying is that because of those fees, they were entitled to favor the controlling shareholder, but in order to keep those fees, they would have had to go against the controlling shareholder, which, under the plaintiff's theory, would have led the controlling shareholder to remove them from the board.
Well, look, go ahead, Ken.
So what's the standard for determining whether the special committee is quote-unquote independent?
Well, I think that there's a presumption of independence. That's where New York law starts.
So it's a presumption of what, though? How are we defining here independence?
So that there's not a relationship that would cause the director to make a decision on something other than the merits of the transaction, Your Honor. And the record here has no indication that
they're not shareholders, right?
They are not. One of the
One of them.
directors held 350 shares, Your Honor. But they are presumed to act in the best interest of the company who they're serving. And keep in mind, right, this whole construct was put in place well before this transaction. The entire idea of protecting the minority shareholders was in place since 2015. The controller made its initial offer compliant with this framework of Kenneth Cole. And what Kenneth Cole promises is if you do that, then your decision-making is entitled to the protections of the business judgment rule. And I'd like to go back to Your Honor's question about coercion, because I think at the end of the day, right, if you take out QIA's vote from the minority, under the plaintiff's own allegations, the transaction still gets approved by a majority of the minority. So what we're really talking about is the inclusion of QIA in the minority is coercive. Baltic Trading eliminates that as a theory. And it also,
and then let me ask you a different question. So you surprisingly, or maybe not so, pick the financial advisor recommended to you by the majority shareholder. That has got to raise some issues. What do you say to that?
Well, I think if the record said the special committee, the unaffiliated committee, took that recommendation and that's all that they had and they ran with it, that would be one thing. But that's not what we have here. What the record here shows is that the unaffiliated committee considered 8 financial advisor candidates. They interviewed 4 of them. They went with Moelis. Moelis was the one recommended by a member of Avangrid's management, but there's no indication anywhere in the record that management had anything to do with the decision other than making a recommendation. And the reality is—
Well, why make the recommendation? That's the point. Why do that?
I was just about to address that, Your Honor. The reality is that you have a board of directors. You had a former lieutenant governor of New York. You had a governor of Maine. They are not experts in M&A transactions, right? They need to get recommendations from somewhere. It is not uncommon at all for management.
Why only one recommendation?
I'm sorry?
Why only one?
Well, they got 8, though. They had 8
No,
candidates.
that's not my question. My question is that if they're trying to be generous and try to help, why they would just target one entity rather than saying, here's a list of 5 or 3, whatever it may be?
It's a fair question, Your Honor. I think it's unanswered by the record, but the reality is that under Kenneth Cole, the committee, the unaffiliated directors, have to have the ability to freely select their own financial advisor. There's absolutely no suggestion here that they were forced to take this financial advisor. In fact, it's the opposite. They identified 8, interviewed 4, and chose 1. And I appreciate Your Honor's time and submit that the decision below should be affirmed. Thank you very much.
Thank you. You have 2 minutes, counsel.
Thank you, Your Honors. I'll try and take the points in reverse order. Starting with the committee's financial advisor, Moelis. One of the other things that the law says is that an advisor is not freely selected if it has, quote, significant financial incentives to support the controller's preferred terms. Here, Moelis was hugely financially incentivized to convince the committee to say yes to a transaction benefiting Iberdrola, and that's because 80% of its fees, $11 million, were contingent on the merger closing. Moelis was only going to be paid that fee if it recommended in favor
Well, I
of
mean,
the
any
merger.
of them were going to be paid a fee, right? Whoever they picked.
Fee structures can be structured in a variety of different
I
ways.
agree, but that doesn't cut to this one financial advisor. Anyone they picked was going to be in the position of making a lot of money off of this transaction.
But the key word,
I don't see that singles out one as opposed to the others.
I think the issue, Your Honor, is that in these kinds of circumstances, as Mr. Ditchfield pointed out, these are directors who are not necessarily familiar with negotiating a multi-billion-dollar merger, and they're going to be looking to the financial advisor for advice.
Well, do you dispute that they identified 8 financial advisors and interviewed 4 of them?
Do not dispute those. I'm focused solely on the financial incentives for Moelis to get a committee that is otherwise not familiar with these issues.
Well, I mean, again, any financial advisor would have had an incentive to do the job.
Sure, but there are cases, and in fact, Mr. Ditchfield's papers cite them, including the Panera Bread case, that talk about how you can alleviate these kinds of conflicts by giving an advisor a wider ambit to, for instance, solicit deals with other buyers or get paid even if they don't recommend a transaction. Here, the only deal on the table, the only way that Moelis would be paid is if it were recommended in favor of this particular transaction, not others.
Can you deal with QIA? What if you take them out of the mix and, according to counsel, they would still have the merger approved?
Sure, I can. May I proceed?
You have to ask.
Yes.
So, okay, I think there are a couple of responses to that. The first response is that Kenneth Cole requires these conditions to be put in place ab initio. So you can't really unscramble the eggs fairly by backing their vote out on the back end, because the procedures are required to be put in place so arm's length negotiation can exist from the beginning. As a logical matter, it's difficult to accept how in a counterfactual world you can do that. As a policy matter, respectfully, I think that doing it in that way is poor policy, because it would encourage controlling stockholders to try and futz around with the vote, and if the only consequence is seeing if it turned out poorly and effectively getting a do-over, you would do it every time. Thank you, Your Honors.
Thank you both. Thank you all. Close. Rubino versus HSBC Bank.
Good afternoon. May it please the court, Your Honor. Sean McPhee of Phillips Lytle LLP for the defendant, appellant respondents, HSBC Bank and HSBC Mortgage Corporation, USA. If I may, I'd like to start with the points on our appeal and then address the points on the cross appeal. As it relates to the appeal, Supreme Court erred in applying a 6-year statute of limitations to the plaintiff's statutory claims. And that's because under CPLR 214 sub 2, where you have an action to recover a penalty imposed by a statute, it's required to be brought within 3 years. Now, if I can just take a quick moment to quote Supreme Court's order. This is on page 7 of the record. And Supreme Court, in rendering its decision, described the nature of this action as follows. Quote, plaintiffs are suing to vindicate a statutory right conferred on them by the legislature, close quote. And it's for that reason, Your Honors, that CPLR 214 sub 2 has to be applied. The fact that Supreme Court applied the 6-year statute of limitations, in doing so, it relied on the Third Department's decision in a case called Key Bank versus Del Norte. But that case is distinguishable for the very reason that's described in Wittenberg versus Bank of America. And the Wittenberg case is squarely on point with the issues on this appeal. And in Wittenberg, the court distinguished Key Bank on the point that the plaintiffs there were seeking to expunge another party's interest in real property.
We've read that case, but let's talk about, how do you distinguish the Third Department case?
And that's exactly the one I'm talking about, Your Honor.
No, I'm talking, okay, so we've read all these cases. How
Right.
do you distinguish that? We have a federal case that says it's a 3-year statute and distinguishes the Third Department case. Do you agree with that?
100%.
Okay.
It's the
So
reason.
then we've read that.
Okay, right. And just for the record, to be clear, the reason why it's distinguishable is because here the plaintiffs are seeking money damages. There, in the Third Department case, they were seeking to expunge an interest in real property under 1921-2. It's a different subdivision of the same statute. Okay, so it's a different remedy, different relief. Now, with respect to, for the avoidance of doubt, one other thing Supreme Court said is the 6-year statute of limitations applies because this is an action upon a mortgage, and so we look to CPLR 213. And actually, this is not an action upon a mortgage for a number of reasons. I think the clearest is, as described many, many years ago by the Court of Appeals in a case called Brick that we cited. The remedy here doesn't arise because of the mortgage. The remedy here arises because of the statute, and that's exactly why CPLR 214 sub 2 has to apply. The Court of Appeals has made it very clear in a number of cases, we cite them in our brief, that where the source of the claim is wholly statutory, CPLR 214 governs. Now, when applying the correct 3-year statute of limitations, all of plaintiffs' claims fail as a matter of law and must be dismissed, notwithstanding their desire to latch on to the American pipe tolling rule. Here, American pipe tolling does not apply for 2 independent reasons. The first of which is it doesn't apply to successive class actions, only individual claims. That's the Supreme Court of the United States decision in Resch, which is incorporated into the Court of Appeals decision in Chavez versus Occidental Chemical in footnote 7. It also doesn't apply, American pipe tolling, in this case because it doesn't apply to the same named plaintiffs. And here, these plaintiffs commenced an action in the Southern District, voluntarily discontinued, recommenced here in state court, and they're trying to essentially toll their own claims. But they're named plaintiffs in both actions. They don't get American pipe tolling for that reason as well. If I could move on to 1921-4, those are the surviving putative class claims that were 2 of the 4 named plaintiffs Supreme Court held may choose to forego the statutory remedy and pursue putative class claims. The other 2 cannot.
Well, if they're out on the statute of limitations ground, they're all out.
That's correct, Your Honor. That's right. But they're also out for at least 4 other reasons under 1921-4. The first one is that so Plaintiff Patakoff got his satisfaction within 90 days of his request. That's in the record at pages 280 to 288. Plaintiff Friedberg, she brought her claim 17 years after she paid her mortgage in full. That's clearly barred by the statute of limitations. Frankly, the plaintiffs didn't even plead a claim under 1921-4 in their complaint. If we look at their second cause of action, each of their allegations—
Your argument that they can't be good class representatives?
Exactly right, Your Honor. You can't be a member of a class that you're not a member of, right? Or you can't pursue an action on behalf of a class when you're not a member of that class. But they plead only 30-day violations in their second cause of action. 1921-4 on its face requires a 90-day violation, and so they haven't pled that. If I could just briefly be heard on the cross appeal, or I'll save it for rebuttal.
Yeah, save it for rebuttal. Okay.
Thank you, Your Honor.
May it please the court, Joseph Tusa, for plaintiffs' respondents who are also the cross appellants. Your Honor, as of course Your Honors know, Your Honor, New York has 2 statutes, along with plaintiff's mortgage, that require a satisfied mortgage to be discharged within 30 days of paying it, or at least 90 days, okay? Now, I didn't hear my brother for the defendants say today that they complied with those statutes. They didn't comply with the mortgage either. They went so far below as to say those statutes are preempted and we as a bank don't have to comply with them at all. Given their lack of a denial of the claims at issue, What the trial court merely held was that these claims are sufficiently well pled, along with plaintiffs' breach of contract claim, that they can go forward past the pleadings and get into discovery. Now, Your Honor, we generally agree with the Supreme Court's decision. He got it right on mostly all points. I think
Well, you may have a very well pleaded cause of action. In fact, a cause of action that on the merits is ironclad. However, the statute of limitations suspends the remedy, and so part of their motion was under 3211A5 on the statute of limitations grounds. So, putting aside the quality of your pleading of those claims, how do your claims fit within CPLR 213 subdivision 4?
Sure. And Your Honor, I think I have a hard time stating it better than our Supreme Court did, but I'll say we stand on the shoulders of 3 prior New York courts that have all looked at the issue quite closely. I've held this is a 6-year statute of limitations on the CPLR 213-4, a claim upon a mortgage. These claims here to dismiss the mortgage lien are sufficiently close to the mortgage that they are based upon the mortgage. We also do, of course, have the breach of contract claim. Now, we had the third.
Well, I guess that's the question. What's the elasticity of subdivision 4? Because subdivision 4 says an action upon a bond or note, the payment of which is secured by the mortgage. So if the legislature wanted to broadly capture claims relating to a mortgage, it could have used language along those lines, but the statute is worded in terms of an action upon a bond or note secured by a mortgage or an interest therein.
It does, Your Honor. It does say that. And, you know, Judge Lebovitz, he looked at the Wittenberg decision, he looked at the KeyBank decision. He didn't get into some of the other Supreme Court decisions that all agreed with KeyBank. But what he said is, listen, we certainly have the one subdivision of 1921 that KeyBank.
What are the damages you're seeking?
What are our damages issues?
You pled that you get the $500 under the statute, right? Because otherwise you would have no damages. You haven't even pled that you had any other damages, right?
Well,
all right, let's assume that the breach of contract claims, but you are seeking the $500, right?
You rejected that.
Oh, you rejected that. Wait, no, did you reject it?
Well, so, okay, I think what Your Honor is speaking to, the remedy under 1921 is the greater of $500 or economic loss.
Right, so, and that's what you're seeking, correct?
We are seeking the greater of economic damages or economic loss.
Right. What?
For the class members that we haven't got to that motion.
If you can't prove that, you would not get, you're saying you'd get nothing.
If we can't prove what, I'm sorry.
Greater economic damages.
If we can, well, then this case is very much like the Glatter case from the Second Department, when if you don't attempt to put in damages of economic loss, and mind you, we're at the pleading stage. If we don't put in if we are unable at the summary judgment or trial stage, or even at class certification stage down the road, to put in evidence of economic loss, then we get the $500 for these named plaintiffs, and potentially
And where do you get that number of $500 from?
Where does it come from?
The statute, right?
It does come from
And
the
you would
statute.
not be entitled to $500 under the statute if you were just having a straight-up breach of contract claim, because you couldn't prove any damages, right?
If we're talking about only the 1921 claim, I would certainly agree with Your Honor.
Yeah.
We certainly do have the breach of contract claim, and the breach of contract, the contract not only incorporates the New York statutes, it has an independent section.
What is independent?
It has, if you look at the, well.
What are you saying was breached other than your statutory obligation to?
There is a section in the mortgage agreements, the uniform mortgage agreements, that require discharge timely after satisfaction of the mortgage. It's
Under the statute, right?
No, that section is in the mortgage. And to commend Your Honor to our pleading, I believe it's paragraph 153 of our complaint, and we're quoting the mortgage agreements, and I believe it's section 23 of the mortgage agreements.
And sir, is there a recognized remedy under the common law for a breach of that covenant or promise in the mortgage or note?
Certainly going back to some of the case law, they do talk about some of the older common law remedies for not satisfying the mortgage. Certainly here in New York, we have actions like quiet title and things of that nature. But here in New York, we have these two statutes under the real property law, real property actions proceeding law, and under the contract. And of course, we're talking about the statute of limitations. We didn't get to the American Pipe arguments, I would commend this court's opinion to the Second Department in Badzio, which
Counsel,
completely
The
answered it.
red light has been on for a while. Thank you.
Thank you, Your Honors, I appreciate it.
All right, you have 2 minutes.
Do my best, Your Honors. Thank you. Just a few points. The breach of contract claim was properly dismissed for a number of reasons. First of all, it's duplicative of the statutory claims. The plaintiffs fully embraced the overlap. In their pleadings, they talk about the breach occurred as a result of or because of the statutory violation. That's clearly duplicative. They raised for the first time on appeal in their brief to this court, they're allowed to plead in the alternative. But alternative pleading doesn't work for them here, besides the fact that it's improperly raised.
Do they seek a remedy, sir, other than the penalties or the remedies provided by the statutes that have been invoked?
No, they don't. But what they do is they're trying to subvert a rule of law, two rules of law. And in fact, this court's decision, you authored the opinion, Your Honor. It's called...
Better find a better authority than that.
Well, Justice Rodriguez was on the panel as well. So that's...
okay.
Now it's good.
Now we're both in trouble.
That scrutinizes my work, so go
That's
ahead.
Brown versus Riverside Church. And the court here said you cannot subvert a rule of law through alternative pleading that would otherwise bar recovery. That's exactly what they're doing here. CPLR 901B precludes the class claims, okay? And so they try and get around that by alleging it as a breach of contract. Can't do it. Also, the statute of limitations. It's the same 3-year statute of limitations. That's this court's decision in Oliver. The contractual obligation adds nothing to the statutory duty, okay? It's really important that
Can I just ask you about paragraph 153? Isn't it true that the bank already provided all the satisfactions and there's nothing more that has to get done? So what would there be a breach under a paragraph 153, which would be breach of contract?
I don't think they have a breach of contract claim, and I think it was properly dismissed, and it should be affirmed by this court. The fact of the matter is the satisfactions had been filed, which is another reason why 1921-4 is not available to them, because the statutory text says it's only where the mortgage has not been satisfied at the time of the commencement. I hope I've answered your question.
Would filing individual actions and then voluntarily discontinuing them toll the statute of limitations?
Not under American Pipe, because it only applies to a class action in the first instance. The point being, we want to discourage individuals from commencing actions while the class actions are pending, and so it's only after that they would file individual claims to protect their claims, once they've been dismissed or voluntarily discontinued.
Thank you, counsel. Thank you both.
Thank you
you all. Okay, 5th and 106th Street versus Hunt.
Good afternoon, Your
Good
Honor.
afternoon. All right.
I thank the court for its patience. May it please the court, for the appellant 5th and 106th Associates, Paul Copy from Rose and Rose. In the brief time, I'd like to focus just on 2 points. First of all, the decision from Justice Moyne seemed to rely primarily on something like res judicata effect from the decision of the Housing Court. The decision of the Housing Court did not raise the use and occupancy claim at all, nor could it have adjudicated the actual use and occupancy claim in this case. The use and occupancy claim in this case covers the period.
Can I ask you, I was trying to find the case about recovering the spread between Section 8 payments and the market rate. Is there any cases that's ever permitted a landlord to recapture the differential?
Sure.
Which case? Because I couldn't
think
find
the
one.
case that we cited was Apollo versus Caputo.
In terms of Section 8?
Yeah, it's the rule is that if the Section 8 is terminated due to, excuse me, let me back up a second. If the tenancy is terminated due to some misfeasance or malfeasance of the tenant, and the landlord terminates the tenancy, once the tenancy is effectively terminated, sure, the landlord is entitled to use and occupancy at the market rate.
I know.
No, not, yes, you could use an occupancy, right? But has anybody ever said, and that use and occupancy is a number other than the rent, the tenant's rent?
Sure, it's the HUD rent.
No, no, no. I think we're not talking about first of all, we're not talking about a market rate tenant to start or any tenant. We're talking about a tenant the tenancy is governed under federal law, right?
The tenancy originally was a Mitchell-Lama tenancy.
Okay,
But
but
yes,
when
it's
the
the
tenant
tenancy
was there-
during the periods of time relevant to this case
Okay.
is a federal tenancy, sure. And HUD sets the rent, and the tenant's share is affordable to the tenant. By definition, the tenant's share is set at 30% of tenant income. The issue here.
Okay, but you're red, so we gave you your 2 minutes. You don't have anyone who's arguing against you, so I gave you the 2 minutes, but it's getting late and I have one more case.
Okay.
I appreciate you staying.
Well, thanks.
Go ahead. If you have one more thing to say, say it, because I feel like you have one thing you want to get out.
Sure. The one thing that I want to get out is that had Ms. Hunt's share of the rent been set at 30% of her actual income, it would have been something roughly about the HUD market rent that she refused to pay, basically because she didn't want to, and litigated a meritless claim that the apartment was rent stabilized, until finally she unfortunately got evicted over it. But this is not a case where we're attempting to victimize a hapless indigent tenant. It's a woman who was well capable of paying her fair share of the rent, 30% of her income, no rent burden on her.
Thank you.
Thank you.
All right. People versus Unique Woodfin. Thank you for waiting.
Center for Appellate Litigation by Molly Booth on behalf of Mr. Woodfin. In the same panel, the court found an instance of actual discrimination, and then moments later, when the prosecution exercised another peremptory challenge against somebody in the same class, the court ultimately found no prima facie case was met. I think that there was a prima facie case, both based on the conversation between, both based on the finding for the first juror, where the court found actual discrimination, and then when you find actual discrimination, that also builds the prima facie case. I also want to add that the defense argument under Batson incorporated the idea that there was no discernible reason for the prosecution to be striking this juror at issue. And so it wasn't just a numbers game, it was listening to the record and not hearing any reason why the prosecution could conceivably want to strike this juror, but she makes her Batson challenge again, and the court initially finds, yes, prima facie case, we just went through this, let's hear the reason. The court hears the reason and finds that there's nothing in the record that supports.
That's not what happened. The court said, I made a mistake.
Well, I'm not saying.
But you're misrepresenting what actually happened. The court thought that I made a mistake and therefore I'm changing the decision.
I don't mean to imply that the court is outcome oriented. I guess I want to get into the record that there is information about what that reason was in the interim. And so once you know that the prosecution has set forth a reason and the court says, I don't see any basis of that in the record, but let's talk again tomorrow. And then the court comes back and understands that there was an interim juror. And I think it is appropriate for the court, for the purposes of this argument, let's say it's appropriate for the court to let's take a look at step one again, because I misunderstood what was happening here.
Right.
And I think let's look at the record that there actually was. And so if the misunderstanding was something that should change, that step one determination, then I understand that let's take a look at that. But instead, the actual record reflected that there was one juror that the prosecution in its brief admits would likely be prosecution friendly. And so not only is that something that really shouldn't disrupt that prima facie case, but also
the juror was of the race that you're saying that they were using the peremptories inappropriately for.
That's correct. And so the prosecution.
So it's either they're using the peremptories inappropriately based on race, or they're not.
Well, yeah, so the juror that the prosecution was comfortable seating is the mother of a murder victim
There
here.
were also other jurors. There were other jurors of that race that were seated with the people's consent, right?
Yes, there were 4 black jurors.
You're limiting your Batson challenge to this particular round, as opposed to the entire voir dire.
Well, so when the defense counsel clarifies the
But
record.
is that appropriate to limit it to just this round, so that people are excluding jurors of a specific race just in this round, although they didn't do that in round 1 and in round 2?
Well, the court actually expressed concern about prior rounds and was surprised that it took defense counsel
Right,
so long, and then defense.
And although, counsel, don't interrupt, and although the judge sustained one of your Batson challenges, it seems that the people changed course.
Because they seated somebody who was crying for having had her own son tragically murdered, I think the
You want to
prosecution could
phrase
have
it that way,
depended
or
on
you
the
could phrase
defense
it
to
as they
preempt.
seated someone in the class that you're saying they're excluded.
Exactly.
And so the judge decides that they get a clean slate after it sustained a Batson challenge. And sorry, there's a couple of things.
That's not what happened, and that is what I am objecting to. The judge said, I made a mistake. You're acting as if the judge went past that and went back and reevaluated what it did at first.
And I think the court is reevaluating its determination about the juror at issue, not the juror. It sat on the jury after a finding of discrimination.
The court was evaluating its determination that you made a prima facie showing of using an inappropriate challenge.
Yes, but moments earlier, the court had sat a juror finding that there was actual discrimination. And so the only interim thing.
So you're saying that once that finding is made, that's it? That every other challenge that's made by the people, that's used by the people, has to be prima facie discrimination?
I'm saying it's possibly the most powerful evidence of prima facie discrimination, and that is why the Second Circuit granted habeas on this issue. I think that it is very rare to find a finding of actual discrimination, and if that interim were 4 rounds or 5 rounds, I would understand completely that there could be dissipation.
May I?
Yeah, okay.
Did counsel limit the challenge to the 6th round?
Initially, yes, but then when the court.
And then the confusion came about in the 7th, right?
No, everything is all in the 6th. Everything we're talking right now is in the 6th round.
Confusion as to Alston versus Chestnut.
Is still the 6th.
It's still the 6th?
It's still the 6th round. There is an overnight in the interim, but when we get back the next day, the court revisits round 1. Defense counsel, step 1 of Batson, and defense counsel says that the interim black juror that the prosecution did not challenge.
The question was it in the same round? And you're saying yes, it was. So
yes,
let me let counsel speak, right?
Please the court, Lindsay Richards for the people. Good afternoon again, Your Honors. So the issue that the defense faced with this Batson claim is.
I'm sorry, just something fundamental I want to get out of the way. What is the prima facie showing? What is the standard for determining whether the defendant made out that prima facie showing? Is it, among other things, totality of the circumstances? Is it unique to, potentially just one juror? What's the test, generally speaking?
Yes, Your Honor. So it's a two-pronged showing that the defense must show in this context. First, they must show that members of a cognizable racial group have been excluded, which is easy enough to show.
Is that all members or some members?
Just members. It doesn't have to be every member, but certainly they have to show a pattern. So the second part of that is they have to show facts or circumstances supporting an inference of discrimination. And this is where...
Would that be established if let's say they show that the people used 3 peremptories to strike black jurors, but then seated 2 black jurors and then used another peremptory to strike a 4th black juror?
No, Your Honor, and there have been cases that a prima facie showing, if it's going to be based solely on numbers, then it needs to be pretty much the entire group of those people, 100% of people who fall into that category, that racial category. And that's not what happened here, and that's why the defense faces an issue with this particular Batson claim, because they're trying to make it a numbers issue.
And the judge went back and said, wait, I had been mistaken about whether you made your prima facie, right?
Correct. And the court was certainly entitled to do that once the court realized that it had.
Once the court decided, when reverts itself on the prima facie finding, the burden never shifted to the people, correct?
That's correct. Once the court determined that there was no prima facie showing of discrimination, the inquiry was over at that point. And
so why was that the judge's conclusion as to step one appropriate here? Because obviously an appellate court could disagree with the trial judge's evaluation of one, and then we have to figure out what the remedy is. But why was the step one analysis or conclusion appropriate here?
of course. So as I touched on briefly, it was because the defense claim was based upon the numbers. The way that they presented their prima facie showing was to say to the court, the next available African-American juror has been peremptorily challenged by the people, when in fact that was not true. The defense challenged the next African-American juror, and the people actually sought to keep that person on the jury. And so the defense then ended up using a perempt to excuse that particular juror. It was the next juror. So there was an interim juror who broke this purported pattern. That being said, also, the court had already, of course, there had been the initial Batson challenge in the same round. The court found that the people's reasons for two of those jurors, prospective jurors, were not pretextual. And with respect to the third juror that the court ended up seating, the people did make a record that we had used a peremptory challenge for a similarly situated white woman. It was relating to large tattoos on the face and the chest. So again, there could be the argument that there was no pattern. The court at that point, the pattern was broken, if there had been a pattern at all, certainly by the findings of non-pretextual basis for using the peremptory challenges of the first two, and then the fact that the people actually fought to seat a person of the protected class.
Do you want to address the other, unless anyone else has questions, do you want to address the other the appellate issues?
Maybe like, in particular, the spoliation of the cartridges?
Sure. So with respect to the destroyed evidence claim that the defense has raised, in this, the defense claims that the people should have been precluded from, well, you know what the defense is claiming, so I won't repeat it. But essentially here, this was not material evidence. The cartridges in themselves were not material evidence. The material evidence was the defendant's response on those recorded jail calls to the police finding the cartridges.
So that because the bullet was so badly damaged that a comparison, even if they had the cartridges, would not have been able to be made, correct?
That is correct, Your Honor, which means that the defendant suffered no prejudice as a result of these cartridges that were not connected to the murder at all at the time that they were destroyed, were in fact destroyed. So he suffered no prejudice at all, and they're not material. He did not demonstrate that they were, and for all of those reasons, the court correctly precluded or correctly declined to issue a adverse inference instruction.
I do have one more question on the Batson issue. When the judge reversed himself, was there an objection by the defense?
There was not, Your Honor, which makes any claim that the court improperly went back to the step one analysis unpreserved. Right, well, I thank you, and I ask you to affirm the judgment of conviction and sentence. Thank you.
Counsel, you have 2 minutes.
Yes. So a pattern is not required for a prima facie case. That's under under SMOCUM, S-M-O-C-U-M, Court of Appeals case. A single juror being discriminated against can be a cognizable Batson claim. Under Jenkins, the Court of Appeals.
We don't disagree with that, but the question here is if your trial counsel is making a claim based on numbers.
Yes, it was not just simply based on numbers. It's both numbers, the prior finding of actual discrimination, because I believe that is part of the pattern one would naturally be referencing.
Right, okay.
And then also a lack of discernible reason from the record that would cause defense counsel's sense to go up of why the prosecution wouldn't want this jury on. I think Jenkins.
Well, so on that, on step one,
yes,
vis-a-vis the prima facie showing, what were the facts or circumstances with respect to that one juror that could form the basis for a valid Batson challenge? What were the facts and circumstances that permitted an inference that the prosecution challenged excuse the juror for an impermissible reason?
So in this case, the prosecution had exercised challenges over the first 3 black jurors of that panel. The 4th juror, the prosecution could almost certainly bank that the defense was going to peremptory challenge that juror because no defense attorney is going to want that juror on their jury. And then the person after that, also a black juror, the prosecution perempted. And then the other thing that is permissible there to use is there's no record reason defense counsel could consider that the prosecution would be likely to base its challenge on, and also the fact that the prosecution had been found to engage in actual discrimination earlier in the same panel, which is
Since the juror that you're saying that no defense counsel would want on their panel so that the people could bank that you would use a peremptory, you challenged it for cause, right?
Yes.
And the people opposed.
Correct.
And if the people wanted that juror off, they just could have agreed with your motion, your challenge for cause.
I think that under the Court of Appeals in 2010, Jenkins refers to the sort of situation that the existence of a juror in the protected class that would
You're almost assigning the responsibility of that peremptory challenge that was exercised by the defense to the people.
What I'm saying, no, of course not, but I am saying that that if the people did not want, I guess there are 2 things I'm saying, that race can be a factor that is being overcome in one juror because that juror has a profile of somebody that looks like they would be extremely prosecution friendly from the limited interactions that can occur in voir dire, but that it is separately a predominant factor in the rest of the jury. And so that's why putting a single black juror that is from the voir dire we have appears to be likely prosecution friendly can't disrupt that pattern that was found before. Otherwise, there could never be a Batson showing. After one Batson showing, you would go right, the people would start from scratch, and like the next 2 or 3 jurors that they challenged would be immune from a step 1 showing, and that's not the case here.
Thank you. Thank you both.